So this is
Recording in progress.
and everyone who is following these public hearings. Thank you for joining us. This is day 2 of the public hearings on the gas bill. Yesterday, we received very comprehensive oral presentations from various stakeholders that have made submissions towards this gas bill that's for us. So today is the last day of these hearings. And in this segment, we're going to get 3 presentations as we started yesterday, and then get clarification questions and responses from those who have presented, and then get another 2 sets. And then we would have considered the business of the public hearings, and then next week we then proceed to the deliberations after the Department of Electricity and Energy has what's in attempts to actually respond to these submissions that will be made by the stakeholders, whether it would have been oral or written only. So we are going to get apologies if there are any mistakes there before we proceed to get the first presentation, which should be from Equa SA. So and if they are already on the platform, please start preparing them in terms of giving them the hosting rights. But now can we get the apologies and confirmation of quorum?
Yes, thank you, Chair. So we have 8 members on the 7 members on the platform. So we do form a quorum, Chair. And then the only apology I received was from Mr. Mbata, who is currently on leave. Otherwise, we sorted, Chair. Igua is on the platform. I see that Mr. Himan is there, so I'll give him co-hosting rights, Chair. Thanks, Chair.
Okay, please grant him. And then after Equa is going to be Offshore Petroleum Association of South Africa. They please get ready to come in after Equa, because we will take all the 3 presentations first and then go on to get clarity seeking questions on all the 3 presentations by the honorable members. Equa SA, the platform is yours.
Thank you, Honorable Kanyaze, and thank you, Mr. Kotze, for the introduction. I trust that we are audible, and if you can just give me one moment to bring up our submission. Thank you, Chair, and thank you, Mr. Kotze, for the opportunity, and also to the Parliamentary Committee, Portfolio Committee on Electricity and Energy. We would like to spend the next few minutes with the committee discussing largely 2 elements of our submission today. The one is more reference to the policy, market, and industry, and the other one is more on the legal technical issues that we have. I'm also here supported by our colleague, Ms. Marianne Wagner from Denise, which will touch on more the legal technical matters. We're just trying to get the presentation on, Chair. Just 1 second. Thank you, Chair. Chair, the draft bill today actually goes a long way in reforming the necessary or creating the necessary reform for the gas market in South Africa. If you look at this graph, Chair, we're not discussing today the gas cliff. That is well understood by all present today. If you look at this particular graph, there are certain challenges which the new gas bill is faced with, and that is largely meeting the gas demand for this large blue dark area. If you open policy documents today, Chair, the it is clear that the South African economy is pivoting towards a reliance on gas energy as part of its energy transition from coal into gas and to more renewable energy. However, we have to test the new gas bill against its ability to deliver this particular gas demand that you see here as we pivot towards a more gas-reliant economy. At the moment, the only part that is certain in South Africa is actually the red line. That is our current gas supply trajectory, and we could potentially face a significant gap in our energy portfolio or our energy mix in South Africa. Just very briefly on this particular map, Chair, is that the Gas Act needs to, in our view, deliver against what we see here presented. If you look on the East Coast, there are significant investments required in LNG infrastructure, in power generation. If you look at the different demand nodes in the Southern Eastern Cape, again, gas to power, gas infrastructure. And if you look at the potential on the Orange Basin, medium to long term, of course, in South Africa, we need to develop the necessary infrastructure in order to meet efficient gas supply into South Africa. The Gas Act, as it reads today, actually does not speak to implementation. And that is a big part of our submission today in conjunction with the legal technical matters. So why is reform necessary? We would like to highlight a particular few points here. Of course, the current Gas Act is designed for a completely different market. And that was largely a single supply position from Mozambique in the early 2000s, as we all know. And that essentially supply system is now sort of reaching its end of its life. The market has changed, and the Gas Act certainly seems to be reflecting these changes as it now relates to LNG, regasification, gas to power, and private sector now which forms very much part of our supply solution going forward. The bigger weakness has been implementation. We are not actually faced with an act that is geared towards implementation, and we have a unique opportunity to actually make this act more implementation focused rather than regulatory focused. So reform must change market outcomes, and of course, not only the wording of the law. The second point we want to raise, of course, is what the bill gets right. We believe that the bill recognizes these necessary modernization requirements. We see that the bill creates a stronger regulator in a much more complex environment. And of course, we see now the introduction of a gas master plan, a statutory plan that creates an important basis for integrating supply and demand and infrastructure and costs. Whilst the direction is right, Chair, the test is whether it can deliver on the implementation of our gas energy requirements in South Africa. Price and affordability, a very important matter. Of course, price is a delivery issue. Industrial users cannot commit, or no one can commit to new supply without visibility on molecule price, transport costs, and timing. So the ability to create gas pricing, which provides us with this visibility, is quite key. Pricing must be testable. We are certainly focused on the efficient and prudent cost, reasonable risk-adjusted returns, should be transparent and independently verifiable. My colleague Marianne Wagner will speak more about that. And of course, the affordability affects competitiveness. So ultimately, pricing has to be affordable. It's got to be testable. And that, of course, is essential to demand. And of course, the bankability and security of supply. The investment environment is key. We're looking at significant midstream infrastructure investments in South Africa to meet our gas demands. And LNG infrastructure, the efficient mechanisms for cost recovery and risk-adjusted returns are certainly recognized as we see it in the bill today. But approval risk remains. Ministerial determinations could become another uncertain gateway for major projects, and we're not sure where those guardrails and those mechanisms reside at this point in time. Again, my colleague will expand on that. Investors need predictability, of course, that goes without saying, but ultimately it needs clear rules, objective decisions, and predictable timelines. None of that is apparent in our current environment in South Africa. We actually faced with a delivery problem. Projects do not fail on one approval. It is not necessarily ministerial determination that will make things happen. And we have to ask ourselves the question, if a minister makes a determination, what happens next? Of course, LNG, like any or other infrastructure requirements, requires permits, regasification, pipelines, transmission access, supply and committed demand. Gas to power as a key enabler for the gas economy in South Africa is critical, and electricity and procurement and grid decisions must align with all these developmental timelines that are so critical in our economy. The current process clearly is fragmented. We are not advancing at the rate and speed that is required, putting significant risk on the South African economy in the form of the gas cliff. The priority is a single timeline development pathway, and we've got to ask ourselves the question whether the Act actually delivers against that statement. Bankability in the financing problem, supply needs committed demand, demand needs delivery certainty, and of course, we're currently sitting in a circular bankability problem. We're not sure what the demand is, and that the investment decisions need to be made in that uncertainty, and we're finding ourselves in very much in a chicken and egg position as these financing gaps remain. The gas challenge is now also a financing and project economics problem, and how do we deliver against this? So the Gas Act, it is welcome that the Gas Act makes reference to the Gas Master Plan. However, the Gas Master Plan remains simply that. It is a plan. It is not a delivery program, and we urge the legislators to actually bring in a very firm delivery component into the Gas Master Plan. It's got to be bolted on or linked to that. Otherwise, we will simply be faced with a document and a government that does not deliver in terms of implementation, very much what is being experienced at present. It's got to integrate the full value chain. Gas is a complex value chain. It needs to connect upstream, midstream, and downstream infrastructure, and of course the demand side in power and industrial demand. It requires accountability, and it needs institutional consolidated timetables and clear responsibilities and regular reporting in terms of how we develop that. Program delivery is key. The Gas Act, we simply sit with a unique opportunity that we can actually make this a living act rather than a regulatory act. A fiscal and credit support framework is critical. We urge the legislator to bring in elements of this into the framework. As you see in other infrastructure projects and frameworks, mainly in power generation or water projects, toll roads, national roads, these fiscal frameworks are mature. We don't have a fiscal framework in midstream gas infrastructure today, and that is clearly lacking and pulling back any investment and developments. That framework is missing, and that should be targeted in the development of how the government can backstop certain public-private partnership elements. Private capital will remain central, but it needs that framework in which to operate. And again, this is a key element that the Gas Act need to address. I think what Parliament should secure, in closing from my end, Chair, is affordable and testable pricing, an investable approval environment, a national delivery program. That is probably key. Otherwise, we're simply going to sit with an act that deals with the rules and regulations. And of course, a fiscal support framework. The bill must convert legal modernization into supply, investment, and more important, delivery. At the moment, it doesn't deal with the delivery element. Chair, at this point, I'm going to hand over to my colleague, Marianne Wagner, to take us through some of the legal technical matters. Thank you.
Thank you, Jaco. Good morning, Chair, and good morning to the committee members. Thank you for the opportunity to be here this morning. My name is Marianne Wagner, and I head up the competition and regulatory team at DENACE, and I am here today representing ECOWA SA. We have walked quite a path with government on this topic. There was a previous bill that we made substantive comment on. We have now seen a complete revised bill, and we are pleased to see that some of our prior comments have been incorporated in what we have in front of us today. In this bill, there are elements that we applaud for being in there. For example, NERSA's powers to align with the competition authorities. We have long grappled with the overlap between these regulators, and we welcome the statutory support for them to work together. There's also a retention of competitional concepts in this bill, for example, excessive pricing, that echoes what the Competition Act says, that makes enforcement easier to understand for everyone involved. The safeguards on delicensing we welcome. There's implied public participation process, which is helpful. IGOSA is also supportive of the enforcement and penalties that's been increased, the compliance notices, the fines, the criminal sanctions. We think the increased powers to NERSA and the regulator is helpful in the industry. And we previously criticized the lack of criteria for exclusivity, which has now been addressed. And that additional guidance in the bill is helpful. So we thank the legislature for that. Just while we wait for the slides to update, what the bill now includes is a more formalized section in section 4 on what we think maximum price methodology should be. And this echoes some of the guidance we've seen the Constitutional Court give us in some of our litigation, not formally saying it needs to be cost plus, but referencing cost and plus elements. And IGOSA has long advocated for this approach. Now, of course, we're entering a whole new world with different forms of gas, different forms of markets, and it's not as simple to apply the same methodology to every form of gas going forward. But our client believes that the principles of cost and plus address adequate market regulation for maximum prices going forward. Where the devil will be is in the detail, and NERSA will have a tricky task, we believe, in implementing cost and plus elements correctly. Cost must be prudently and efficiently verified, and this includes potential upstream acquisition costs, particularly where there are related parties. We believe that currently there's a lacuna in the legislative regime that allows vertically integrated firms to purchase from themselves with a lack of visibility of upstream cost acquisitions. And we'll address this further under the information access point later. But we believe that whilst cost plus, as referred to under section 4 of the current bill, is adequate, there needs to be more detail given to how these are checked, implemented, and verified going forward. Jaco Iman from IGOSA has addressed you on the issues of the gas master plan. We welcome the master plan being referenced in section 27 of the new gas bill. We think a coordinated approach is a good one. Where we think it is lacking is the implementation element. What is lacking in legislation is once there is a bill, a gas master plan, what needs to be in it and how it needs to be implemented. What we are asking for is clearer responsibilities to be assigned in the gas master plan, including which government departments need to be involved, what they need to do, how they need to coordinate amongst themselves. And then when we get to the implementation point that my colleague referred to, define timelines, decision-making processes, and accountability for delivery to make sure that the plan doesn't sit there as a document never referred to, but one that actually gets implemented with the support of the actual new Gas Act once in place. Moving along to the ministerial determinations, we note that section 28 of the new gas bill addresses this. What we find unclear is when a new project is undertaken, whether you need ministerial approval if no prior determination has taken place. And we note that the process refers to fair process, but it doesn't set out in any form of detail what the process is. So we ask government to give consideration to what that process is, how it will be implementation, and to give the market certainty that there will be checks and balances in how this ministerial determination would be rolled out. As my colleague referred to earlier, whilst we applaud ministerial involvement in this important market, we don't wish to add unnecessary red tape and bureaucracy that could avoid investment in the market and in the country. Moving along to the issue of third-party access and alignment, we addresses fair and reasonable access. but it does so for uncommitted capacity. And what IGUA SA and its members are concerned about is that the capacity would be committed in a way pre-access that would not be fair and equitable. What we ask this committee to think about is whether there can be a process to get fair and equitable access to infrastructure, gas, all the elements referred to in Section 18(1)(d), pre-commitment, to make sure that there is full access, not just at a later stage once there's been a commitment, but from early on. And what we also ask for, and this aligns with some of our later comments that we'll hear about access to information, is visibility on what capacity is available and what not. It is very difficult for third parties in the market to understand what access is available if information about capacity and uncommitted capacity is not readily available to the market. When we talk about the prohibition against discrimination, this is an issue we've long grappled with NERSA and on the previous version of the bill. The current Section 22 of the Gas Act does not allow discrimination to related entities. And this, we submit, is a very important element of the current Gas Act. This prevents integrated firms from self-preferencing in a way that gives them a benefit over third parties in the market. When the previous gas bill came out, it was drafted in a way that we thought was unpalatable, and we're glad to see that some of our comments were taken into account, and that in the current gas bill we're considering, there is unfair discrimination with reference to the Competition Act. We're grateful for the fact that this is in there. However, we would argue that the gas bill needs to still include wording to specifically prevent licensees from favoring related undertakings.
Can you please move towards closer? Time is up. Towards the conclusion, sorry.
All right. So two points in conclusion from me is we ask for related undertakings to be included specifically to avoid a skewing of market outcomes. And then the last two elements we just ask for in our written submission that we ask this committee to consider is the information vacuum in which the third party operates. Currently, when we ask for information, there are payer exclusions that does not give the third-party market access to adequate information to allow them to make meaningful engagements or submissions to the regulator on what the impact is on the market. We call for a regime similar to that under Section 44 and 45 of the Competition Act, at the very least to give advisors and independent third parties access to commercially sensitive information to allow them to meaningfully grapple with the complicated issues licensees are dealing with, and to give them the opportunity to meaningfully assist the regulator in coming to their conclusions. And then the last issue we ask for is more certainty on complaints. I'm mindful of the fact that our time is up. We've put it in our written submission. We have called for certainty on complaint procedures and processes and expedited relief where necessary, to give the market access to remedial access where required.
Chair, thank you very much for the opportunity. I think in closing, it is clear and evident to us that the Gas Act, as it is drafted today, certainly entrenches the modernization required in this market in terms of its regulatory and decision-making powers. What it doesn't do is create the implementation framework for very much needed gas development economy. If we don't create that particular framework or incorporate it, this committee will not be empowered to keep government accountable for the delivery of a future gas economy in South Africa that spans upstream, midstream, and downstream, and the integration of those disciplines into the supply of efficient gas to South Africa. We thank you, Chair, for the opportunity.
Thank you. Opasa, you are up, and please do be mindful that we have 20 minutes for your presentation.
Thank you, Chair. Okay, good morning, everyone. Thank you very much to the committee for allowing OPASA to carry out our oral submissions on the topic this morning. So who exactly is OPASA? OPASA is a member-funded body that represents the offshore upstream petroleum industry in South Africa. The entities that are members are on the screen, as you can see. The membership of this association consists of companies that have applied for or hold permits, exploration rights, or production rights, or are in the process of applying for these offshore South Africa. The members are governed principally by the Mineral and Petroleum Resources Development Act, the MPRDA for short. However, shortly, or at least once it is commenced, will be regulated under the Upstream Petroleum Resources Development Act, or UPRDA for short. Thank you very much for the opportunity to present our submissions. We will just retain our submissions and to just 4 large points. The remainder of our submissions are contained in the written submissions document provided to the committee. And so we'll just focus on these 4 points, which we feel are the most important parts of the process. The first point is essentially the upstream carve-out, or to essentially delineate the UPRDA scope from the gas spill scope. The second is relating to producer sales, that is people or companies that hold production rights and are then commencing with sale of indigenous gas, potentially. And then the third is around price regulation and dealing with this initial process of commercializing gas at the source by these production or petroleum right holders in the future. And then third-party access specifically, and where we see there might be a potential for overlap between the UPRDA scope versus the gas bill. So essentially, in terms of the first point, there's 3 different phases, everyone obviously understands: upstream, midstream, and downstream. And essentially, the upstream processes, exploration, appraisal, development, drilling, production facilities, subsea systems, gathering, pipelines, processing at field level, etc., all fall under the scope of what we call as the UPRDA. Then midstream, downstream, as everyone colloquial knows, will be covered by the gas bill, or at least the scope of the gas bill. And obviously, in terms of regulatory authority, we have under the UPRDA, we have the Petroleum Agency that governs, acts as regulator essentially. And then in terms of the gas bill, you have a different regulator. So essentially what the industry would want is to have this clear delineation between where the upstream regulation in terms of the UPRDA governs matters and where the gas bill then intervenes on the processes. Bearing in mind that potentially you have the starting point when production rights move to commercialization, there is, as part of the decision to proceed to make a final investment decision, at that juncture, it is part of that consideration whether there is a commercial or an economic commercialization or gas market available. And that forms part of the consideration of moving from an exploration process to a production project. So it's almost like what we call a first gas scenario. So that first gas point, or that first trading point, is a little bit uncertain in terms of the act. What exactly do we mean? And specifically in terms of the proposed clauses 1 and 10, is that this essential first gas option, this producer's sale, disposal, lifting, marketing, or commercialization of petroleum, it could be treated as licensed gas trading in terms of the gas bill. And then there could be this strange overlap between the UPRDA scope and the gas bill scope. And then this would essentially result in a duplicate licensing, maximum price regulation, which is activities that are actually governed by the upstream petroleum rights and in terms of the current UPRDA version that is out. What we had proposed in our submission was to expressly exclude upstream producer sales unless the producer separately carries on a downstream trading activity or a midstream trading activity. And that we had proposed specific wording in terms of what the definition of trading could exclude in order to facilitate that clarity in the definition of trading in the Act. The third point is relating to clauses 3 and 4 in the gas bill, and it relates to the maximum pricing sections of the gas bill. Essentially, as I've mentioned previously, as part of the decision-making process in order to decide whether to move from exploration phases to production phases, a key part of that is, of course, a gas market or at least commercialization considerations. And in terms of the Act, yes, we do understand that there's this overlap and that we want to make that clear, as I previously mentioned. But in any case, we do feel that it needs to be explicit in the section that producer sales and upstream arrangements are regulated under the UPRDA. There's certain project economics that are taken into account into decisions whether to make an FID decision on a gas project. And if this is then subject to maximum price regulation in terms of the gas bill, there could be some overlap or confusion between the scope of the UPRDA and that regulator versus the scope of the gas bill and that regulator. So suggestion was to insert an express exclusion confirming that maximum price regulations do not apply to first sale of domestically produced gas by an upstream producer, and this is in relation to the UPRDA definitions, of course. And also not for these kinds of maximum prices to apply retrospectively to any kind of gas sales agreement. And this is in relation to that initial gas sales agreement, which justifies the project of moving from exploration processes to production processes. LNG supply agreements, tolling agreements, terminal use agreements, or production sharing arrangements. So this is all in relation to that first initial, justification for the production process or the production project. And then also ultimately, if producer sales are ever assessed, further downstream and it relates to indigenous gas, it is suggested that some of the methodology relating to the cost factors of upstream are incorporated in that consideration. So essentially that's factors that are relevant to upstream economics, full life cycle costs, exploration risks, time value of investments, etc., to be included in those kind of considerations as well. Then the last point that we will touch on is just relating to clause 18 and third-party access, and essentially where it might seem that the gas bill is encroaching onto the UPRDA considerations. Specifically, the UPRDA regime in section 668 regulates access to upstream petroleum infrastructure, with the Petroleum Agency determining tariffs, etc. And essentially, we have suggested that the gas bill needs to be explicit to point out that it should only apply where capacity is genuinely uncommitted, existing contracts and financing are protected. A lot of the upstream projects are very much capital intensive. This is a key consideration in any downstream or third-party access to anything. Safety, integrity, and reservoir management relating to upstream projects also needs to be preserved. And then on top of that, the most important point is that that the facility should not be deemed upstream infrastructure, which is already regulated by the UPRDA. So anything outside of that would fall under the gas bill. However, anything that is defined as upstream infrastructure in terms of the UPRDA would fall outside of this. So just to sum up, the high-level concerns of the upstream industry is as follows: these 4 points essentially around this. There needs this clarity on the demarcation between the gas bill and the UPRDA and how exactly that will be managed. And we had suggested some kind of a carve-out for upstream operations and infrastructure. And then also that producer sales could be captured inadvertently as trading. And this is that essential, that first gas, that first justification for the project and commercialization of that project. And that there shouldn't be a duplicate trading license for this initial licensing, which is already dealt with in terms of the UPRDA. Then also the access to infrastructure, that the fact that there's already a provision in the UPRDA relating to access to infrastructure, specifically upstream infrastructure, and then that is clear in the gas bill. And then the last point is on price and access rules. Essentially, the upstream projects have economic concerns. We need to justify the projects before any kind of investment or FID decision is made, and this needs to be protected, or else those decisions might never ultimately be made because there might not be certainty in relation to pricing, etc. So that is really, those are the key points. we have submitted some more smaller or lesser important points, and that is contained in OPASA's written submissions. We thank the committee for allowing us this opportunity, and of course we remain available for any kind of engagements going forward and to clarify or to assist in any way possible with the process. Thank you very much.
Thank you very much to you, OPASA, for the presentation. Please do stay on, because after this last presentation, we then have clarity questions to all three presentations that we have received. So we'll now move on to the FW Declare Foundation. Have they been given hosting rights?
I'm not sure if they are on the platform, Chair. FW the Clerk Foundation?
Honorable Chabeleng?
Thanks a lot, Chair. Chair, I just wanted to make a cautionary note that in this presentation, this is a public hearings, which means we have members of the public listening into this through YouTube and other mediums. Can we just actually explain some of the acronyms? Because we use quite a lot of acronyms in the industry. Some of them we can just quickly just mention them so that people are aware, because not everybody is a guest expert or a specialist in the field. Even some of the legislators don't really know much about the space. So maybe, on the presentations, if we can just explain some of them. I don't want to disrupt and start asking, what does that mean? What does that mean? I just wanted that input. Thank you so much, Chair.
Thank you. I think the individuals that are still going to present on behalf of their stakeholders have taken note of that special request. So there's no representation from in the FW Declare Foundation.
It doesn't look like it, Chair. They're not on
Okay,
the
I think
platform yet.
let's take the clarity-seeking questions and respond, and fuels industry get ready to come in after this short segment of clarity-seeking questions and responses. So can you please get the hands, Honorable Milam?
Chair,
Yes.
just before the hands, can we just check if those other three are on the platform?
Please check them whilst we get the clarity-seeking questions. But if Minerals Council's SA is already on, and Black Business Council and Fuels Industry SA, if you're already on the platform, as soon as we're done with short segments of clarity-seeking questions and responses, you will be allowed a chance to present, and you'll be granted a status of co-host so that you can be able to share your presentation and deliver your oral presentation to this public hearings. So can you please go on to the questions now? Please do, honorable members, indicate who the question is directed to. It really helps so that they note the questions as they are being asked. Honorable Milam, and then afterwards, Honorable, I don't know, I don't see Conrad. Okay, it's Honorable Drink afterwards.
Thank you, Chairperson, and good morning to the committee and the presenters. My first question is for Igua. So in your presentation, you advocate for a strict cost-plus methodology. The current drafting of Clause 4, how does that fail to prevent double counting of costs, margins, risk allowances, etc., by vertically integrated gas suppliers? That's the first question. The second is relating to approval bottlenecks. The ministerial determination requirement under Clause 2810, how does that create a circular bankability problem between supply, midstream infrastructure, and industrial off-takers? So that's the first presentation. The second one is for OPASA, and it relates specifically to the proposed carve-out for upstream sales in clauses 1 and 10. What's the impact on current offshore gas development, for example, blocks 11B and 12B, in terms of bankability and final investment decisions? Second question, the third-party access regime that you are proposing under Clause 18, or that is proposed under Clause 18 of the gas bill, how does that conflict with Section 68? And how can we resolve that to ensure a non-conflicting access regime? Thank you.
Thank you, Honourable Milam. If we may, Chair, just address those two questions. I'll defer the first question to my colleague Marianne Wagner, and I'll take the second one around the approval bottlenecks.
Thank you for that question. So addressing the issue about cost plus, the Section 4 of the gas bill refers to prudently incurred cost. What we are seeing in reality is where you have a vertically integrated firm, they can have an agreement for acquisition between different entities in the same group. And the cost is then simply the cost at which the molecule was self-acquired from an upstream entity. And there's a question about the regulatory power to further interrogate the upstream costs within that entity and not just to accept the purchase cost where the one hand of an entity buys from the other. So whilst we principally support cost plus, we are calling for more visibility and a more deeper analysis of acquisition costs, particularly in instances where there are upstream acquisition between vertically integrated entities. I hope that answers the first question.
Thank you, Chair. If I can then address the second question by Honourable Milam, which refers to the ministerial determination and the certain thresholds to which that may apply. So we hold the position that simply another layer of ministerial determination may simply present another barrier to investment, right? Markets generally dictate where there's mature markets in terms of sufficient supply and demand. And in those circumstances, of course, ministerial determinations of this nature may simply introduce another layer. However, what we see in the midstream infrastructure space is that these create sort of natural monopolies, mainly. And to the extent that the ministerial determination referred to that, we would support this. However, these decisions need to be rational, ultimately, and economically viable and feasible for the country. So it is very important that that these ministerial determinations sort of take place in the framework of what is rational, what is necessary for the country, and what the markets require to smooth out any particular market imperfections, particularly in infrastructure of this nature. Clause or subsection 11 actually limits the reference to infrastructure. It simply refers to transmission facilities and regasification. It does not necessarily refer to storage and gas. So there's a limitation in terms of that. Ultimately, what we're saying, Honourable Milam, is that a ministerial determination is one thing, but what next? We're not sure what the Gas Act is actually referring to once a ministerial determination has been made in terms of what happens. To put another layer onto this, of course, it is absolutely important that the Gas Act goes beyond implementation simply through ministerial determination. There are multiple sectoral coordination initiatives that are required. We've long advocated for a centralized approach to the development of the gas sector. We've heard earlier submissions around the integration around upstream, midstream, and downstream. This simply refers to midstream. So the integration of those three disciplines in the gas sector is critical, and that is where the Gas Act also falls short in terms of the implementation and the centralized implementation on the back of actually fiscal framework development. Thank you.
Honourable Green.
Thank you, Chair. Chair, let me just also quickly appreciate the presentations. And let me firstly say my first question, I think, has been answered. That's with regards to ministerial determinations. That's with IGUA. My second question, though, is with regards to the issue of process fragmentation. So IGUA has indicated that on delivery, the current process is fragmented. So what would your solutions be to streamline the process rather than having a fragmented process? And then the second question, Chair, is to Opasa. What is the nexus of any contradictions or areas of conflict with the gas bill and UPRDA that you've mentioned? Thank you.
Honourable Chair, Honourable Thring, thank you for the questions. If I may proceed in answering the issue around process fragmentation and the streamlining around that. Let me give you a very practical example of what is actually playing out at the moment in the gas sector. The Department of Electricity and Energy is not addressing the gas cliff directly. It is in fact directing or trying to address the gas issues through solving an electricity issue through gas to power. So there's a misguided approach at the moment in terms of solving gas-related issues. As we increase more gas demand, we will need probably in the region of about $10 billion worth of investment in midstream infrastructure over the next 50 years. Currently, there's no coordination in terms of how do you make this bankable in terms of stacking the demand for gas, ensuring that the delivery of infrastructure takes place, and that the molecule upstream is available, whether that is through upstream resources, domestically, regionally, or LNG. So what we've long advocated for, Chair, is as we pivot towards a new significant energy carrier in the South African economy, is that this Gas Act, and in fact, that the Minister of Energy and Electricity actually, or perhaps even the presidency, creates a centralized platform where upstream, midstream, downstream, and the fiscal frameworking around all these initiatives can be coordinated together with all the approvals, whether it sits in the Ports Act or wherever. So this act needs to be an act for implementation. And the centralized approach across all these disciplines are very much important. At the moment, for example, again, midstream and downstream elements in the gas energy sector actually resides with the Department of Electricity and Energy, whilst upstream resides with the Mineral and Petroleum Resources. These things need to be coordinated. At the moment, they're not. And that is what we're advocating for, and hopefully could be introduced in the Gas Act in terms of the centralized approach. Otherwise, we will miss the energy boat in South Africa, and we will not get our heads around the gas cliff as a start, and of course, the full realization of what the gas economy may mean for the South African industry and mining sectors. Thank you, Chair.
Thank you.
Yeah, my question to Opasa hasn't been answered, Chair. That's with regards to any contradictions or areas of conflict with the gas bill and UPRDA.
Opasa?
Thank you, Chair. May I proceed?
Yes, please do.
Okay. Thank you very much. I'm just going to run through the questions that I did also get from Honourable Kevin Malham as well, if you don't mind. Honourable Wayne Thring.
No problem. Proceed.
Okay,
Yeah.
thank you. Okay, so your first question was around what is the effect of potential pricing or maximum pricing on commercial projects, for example, 11B, 12B, or the gas find there. Obviously, Opasa cannot talk directly to a specific project. That is for the rights holder themselves to talk to. However, on a more general point, commerciality is a key aspect in a consideration of whether a project proceeds from exploration phase to production phase. It's part of the consideration of, so much so that in the actual UPRDA, there's a section relating to commercialization and having a gas economic justification for a gas market, for example, and that is part of the considerations of whether to proceed or to make the jump from exploration to production and to ultimately make this decision called a final investment decision, which is essentially where the rights holders choose to invest and proceed to the next stage and, start building the production facilities and things like that offshore. So that is really where it comes in. It's a very important consideration. And it's really subject to market forces, subject to the bankability of a project. It's based on the costs of actually developing a field offshore, etc. So it's a lot that goes into that, and it's quite specific to upstream, offshore, and it's not really as much of a concern further down the different phases in terms of the upstream, midstream, downstream concepts. Then, in terms of your second question around how exactly does the gas bill and the UPRDA constrict or not work well together in terms of access to infrastructure. So in relation to the gas bill, for an example is that in terms of section or clause 3D, it states functions of the energy regulator. The energy regulator must, in accordance with this act, regulate third-party access to gas facilities, for example. Then you have section 68 of the UPRDA, which then says actually the petroleum agency may direct that upstream petroleum facilities which are owned by petroleum holders may be used by third parties, etc., etc., etc. So you have this seemingly direct conflict between two different regulators governing similar aspects. So it's really just us asking, okay, can this be clarified? You know, we don't want to get to the point where we now need to utilize these sections and then have to face with, okay, who has jurisdiction? Where's this line actually drawn? So that's really the tension that we're highlighting. Then moving to Honorable Wayne Tring's questions around where exactly the pain points, or at least the friction is between the nexus between the UPRDA and the gas bill. This relates to what I've just said now around facilities, where it seems like there's some conflicting provisions. And then also relating to maximum pricing, as I've explained earlier as well, where you have this covered in terms of the UPRDA, but it's just not clear in terms of this first gas scenario. Obviously ongoing, if you are carrying out a full midstream and downstream activity, that is obviously clear, that runs through the gas bill, but there's this in-between stage that is not clear. And then in terms of just generalized licensing for construction and so forth, for offshore infrastructure specifically, that is governed in terms of the UPRDA, in terms of the licensing. Well, now at the moment it's governed in terms of the MPRDA. Wherever I say UPRDA, there's an equivalent in terms of the MPRDA, just for your information. It is already governed in terms of your petroleum rights, your right to develop the actual offshore field. And that is where there's potential overlap, and that's where it needs to be clear where this middle line is. Where does the UPRDA end and the gas bill start? I hope that is clearer. Thank you.
Thank you. Are there any further questions? Okay, can you please move on to get the SW Declare Foundation? I'm told they've now joined.
Thank you so much, Chairperson. Is it possible that I share my screen?
Yeah, we'll be allowed to get co-hosting rights. Can they please be given co-hosting rights?
You've been given co-hosting rights, Mr. Yusuf.
Thank you. Thank you so much. If you can see my submission in front of you, my name is Ismail Jusub. I'm the Manager of Constitutional Advancement at the FW de Klerk Foundation. Thank you for this opportunity, and I ask that our submission also form part of the record. Our submission is 38 pages long, so I'll not read the entire 38 pages, but rather just to explain our central concern and take the committee to the provisions where our focused amendments we think will make the bill fairer and clearer and more effective. So I wish to begin on page 2 of our submission on paragraph 8. Herein we see that the FW de Klerk Foundation supports a modern gas statute. Yes, South Africa does need a predictable framework for investment, for supply security, for competition, for safety, and for environmental responsibility. And so, therefore, we support NERSA remaining the licensing authority, the National Gas Master Plan, stronger compliance, and public comment on ministerial regulations. For us, this is not really an argument about gas investment or transformation. It is an argument that these objectives will be better served when public powers are more clearly defined and supervised. If we were to look at page 3 of our submission, paragraphs 9 to 11 here, this is where we see that our central concern as the FW de Klerk Foundation is the combined breadth of several powers. The bill, we think, allows undefined ministerial quote-unquote imperatives for every license application, broad license conditions, binding infrastructure determinations, future triple BE mechanisms, extensive NERSA rules, potentially uncapped daily fines, and then imprisonment for non-payment of an administrative fine and wide exemptions. So we see that these powers are not automatically unconstitutional, but the difficulty is that some lack clear criteria and procedures and limits or reasons. So we feel that in ordinary language, the Act should state the important rules of the game, but they should not entirely depend on the good sense of whoever exercises power later. I wish to skip a few pages of my submission to go to page 11 of our submission, specifically paragraph 33 of our submission. Here we speak about clause 2H of the bill that promotes gas companies owned or controlled by Black people. Clause 36 1L permits the minister to prescribe triple BE mechanisms. The FW de Klerk Foundation accepts the constitutional importance of redress. Obviously, apartheid has excluded many South Africans from capital, training, management, and productive ownership, but we also recognize that the Triple BE Act is binding law and must be applied where Section 10 requires. So our concern is not whether transformation should occur, but whether the bill will produce broad and lasting transformation. This then dovetails into page 12 of our submission to paragraph 38, where we propose then a needs-based and an outcomes-focused object. This sort of approach would consider income, education, geography, disability, unemployment, enterprise size, and access to capital. Instead of the model proposed by the bill currently, this would rather measure skills, employment, entrepreneurship, productive ownership, employee and community participation, and access to finance. Because committee, for us, ownership does remain relevant, yes, but we don't feel that it should be a substitute for changed lives. A heavily financed nominal shareholding structure may leave beneficiaries with actually very little value and just increase project costs. Training artisans and supporting new suppliers and creating durable jobs, for us, actually would be better in giving genuine value to many more people. I then move to page 13 and 15 of our submission to paragraphs 40 to 48, and I'm willing to make our submission widely available to everybody if it hasn't already been. Here we ask Parliament to avoid a second uncertain licensing code layered over the Triple BE Act. So we're not saying that the bill presently contains a quota, it doesn't, but we do ask that future mechanisms be limited to more flexible evidence-based targets and not automatic racial disqualification. We feel that outcomes should be measured, that fronting should be referred to the Triple BE Commission, and that Parliament should be given evidence showing who's actually benefited, because the constitutional question is whether the measure is actually reasonably capable of advancing people disadvantaged by unfair discrimination. If we were to move over to page 15 of our submission, to paragraph 49 of our submission here, we then posit that clause 15.3 allows the minister to publish quote-unquote imperatives that NERSA must consider in all licensing applications. But our problem is that that word is undefined. It could mean policy guidance, it could mean a minimum requirement, or a direction deciding the result. And so the FW de Klerk Foundation recommends defining it as a published policy consideration, supported by evidence and consultation, which doesn't dictate any individual outcomes. From this, we draw from the Constitutional Court in the PG Group case that's referenced in the submission, that a methodology or guideline should not be applied mechanically, where that would produce an irrational or unlawful result. And so NERSA must consider national policy, yes, but still apply the Act independently to the evidence. Moving over to page 16 of our submission to paragraph 54 of what we've submitted to the committee, we say clause 28.6 says that NERSA is bound by a ministerial infrastructure determination, but the FW de Klerk Foundation proposes clarifying that NERSA must give effect to it only to the extent that it is lawful and within the minister's powers and consistent with NERSA's duties. A national infrastructure decision cannot sensibly require approval of a facility that fails safety and environmental and technical tests and standards. So if we move over to page 17 of our submission, this page, to paragraph 55 of our submission, we see that clause 36, that properly requires public comment on ministerial regulations. But clause 37 gives NERSA powers to make rules affecting applications and prices and capacity and investigations without expressly requiring consultation before adoption. It then further allows rules about consultation in clause 37S, but it doesn't require consultation on NERSA's own rules. And so the FW de Klerk Foundation recommends draft publication, supporting evidence, and a reasonable time to comment, consideration or representations, and final reasons, simply because we feel that these steps improve the rules before they bind people and would also reduce litigation and save costs in the long run. Turning over to page 18 to 21 of our submission, to paragraphs 61 to 75 specifically, so these 2 pages of our submission, we're looking at licensing fairness. We look at clause 14 specifically, which permits objections only from someone whose rights may be materially and adversely affected. For us, that is too narrow for a forward-looking process. A municipality or a consumer body or an environmental organization or even a community may hold vital information before it can prove present harm to a right. So the FW de Klerk Foundation in this regard proposes that any interested or any affected person should instead be inserted. Decisions should be written and reasoned and public and subject to lawful confidentiality. If we turn over to page 21 of our submission, to paragraph 76 specifically, here we look at gas networks. We see that gas networks can be natural monopolies because duplicating pipelines can be wasteful sometimes. So yes, you might have some exclusivity. Some exclusivity may attract investment, but clause 17 allows exclusive areas, and clause 18(1)(t) can require most customers there to buy from one distributor. And so what this does really is that it locks customers into one supplier. And so the FW de Klerk Foundation asks that exclusivity exist only where it is necessary, and then for no longer than efficient investment recovery requires, and subject to service and affordability. It should also be reviewed and narrowed when competition becomes practical, because we prioritize competition in this regard. The gas master plan then appears at page 23 of our submission, paragraph 85, where we look at clause 27. Clause 27 is one of the bill's strongest features, we feel, but the FW de Klerk Foundation nonetheless recommends transparent high and low demand scenarios, a better affordability analysis, and disclosure of who carries the cost if infrastructure is underused. Turning over to page 26 of our submission, to paragraph 94 specifically, we look at clause 28. And here we see that clause 28 permits the minister to determine the type, the size, the timing, and the buyer of new facilities, to bind organs of state to direct procurement and issues, guarantees, or indemnities for publicly owned facilities. But our problem is that these decisions can create long-term public liabilities. And so therefore we feel that they should rest on published demand, affordability, and again, a better competition analysis and consultation and reasons. We also found that there's a specific problem at page 27, paragraph 98 of our submission, which then refers to clause 28.5 of the bill. Clause 28.5 mentions section 217 of the Constitution, where the facility or supply is not provided by an organ of state, but section 217 applies whenever an organ of state contracts for goods or services. The eventual supplier's identity doesn't remove that duty. And so the FW de Klerk Foundation then proposes stating that every procurement to which section 217 applies must comply with section 217 and applicable procurement and public finance law. A state guarantee is not free money. It simply transfers the risk to the public. if demand falls or if costs rise. So clause 28 should not impose an unfunded purchase obligation on a municipality or displace municipal authority over gas reticulation and planning and roads. Moving over then to page 29 of our submission, to paragraph 107 of our submission, which references clause 6, we see that clause 6 allows warrantless entry into regulated business premises for routine inspection and investigation of suspected offenses. We feel that routine safety inspections are necessary and regulated operators have reduced privacy expectations. But we also feel that an intrusive search for criminal evidence is different. We looked at the Constitutional Court's reasoning in Gertner, and so therefore we recommend that a warrant for coercive investigations must be applied for. You must have a warrant for coercive investigative searches, except for narrowly defined urgency with protection for privileged information and electronic data. If we look at page 31 of our submission, committee, and specifically paragraph 114, which looks at clause 32 of the bill, we see that clause 32 permits the greater of 10% of annual turnover, or 2 million rand, for every continuing day of non-compliance. Now, that daily limit has no clear overall ceiling. A fine must deter wrongdoing, but it shouldn't reflect gravity and fault and harm and cooperation and continuity of supply. So the FW de Klerk Foundation here recommends that there be an aggregate ceiling applied and a fair hearing. This also dovetails to clause 38(1)(b) of the bill, which makes failure then to pay an administrative fine an offense carrying up to 10 years imprisonment. Its reference to clause 32(2) is also incorrect, because clause 32(2), that subsection concerns representations, but the power to impose the fine is actually in clause 32(1). So we feel that the ordinary remedy for this should be civil enforcement once the fine is final, but mere non-payment shouldn't in itself warrant a 10-year crime. Then if we look at page 33 of our submission, specifically paragraph 122, which references clause 39 of the bill, here we see that clause 39 allows exemptions for national security, for strategic interests. You'll see it mentions economic interests and international obligations. And for this, we see that some exemption power is reasonable. But quote unquote economic interests for us is extremely broad. The bill requires no public consultation, reasons, or maximum duration, or periodic review. And so therefore we ask for those safeguards, and we ask for no exemption from core safety or environmental or rehabilitation duties. This also explains why clause 40 then needs transitional arrangements for pending applications. So honorable members, I wish to then conclude with pages 35 to 37 of our submission, which you'll find here at conclusions and consolidated recommendations. In essence, the FW de Klerk Foundation asks Parliament to yes, retain the bill's important objectives, but to place lawful boundaries around the powers that are used to achieve them. Transformation should be real and measurable. NERSA should be the licensee. NERSA should apply the law independently. Monopoly rights should be temporary and should be supervised. Planning should account honestly for cost, for climate, for communities, for municipal functions. There should be procurements and guarantees that should remain constitutionally and fiscally accountable. Enforcement must be firm but proportionate, and exemptions should not become private escape routes from public law. We feel that these amendments are not obstacles to investment or transformation. We feel that it gives better legal certainty, fair participation, and accountable power, which are conditions for investment in the first place. Gas projects may last for decades, but the public and investors and communities need to know how decisions will be made, what limits apply, what remedies exist when power is misused. So with the amendments in our submission that we recommend at paragraph 137, all of these recommendations, we feel that the bill can provide a stable, legitimate, and constitutionally sound foundation for South Africa's gas sector. Thank you very much, committee, for the opportunity.
Thank you, Mr. Joseph. We will then take Green Connection, and then if we have another entity or other stakeholder that is ready, we'll also take them and then take answer seeking questions from 3 presentations. So can we please get Green Connection in, and can they be given co-hosting rights so that they can do their oral presentation?
Sorry, has the co-hosting rights been granted?
Yes.
Is the presentation up? Can you see it?
No. Nothing yet.
And now?
No, nothing yet.
Oh, shoot. If you can just give me a moment
Sure.
to share it from my side. Okay.
You can see it now.
Yeah, that's great. Thank you. Okay, thank you very much. My name is Adrian Paul. I'm presenting on behalf of the Green Connect. Yeah, detailed written comments were submitted on Friday, which obviously we won't be going through in too much detail. We'll just be focusing primarily on the main concerns relating to the gas bill. And we thank the Portfolio Committee for this opportunity. So just at the outset, just to point out that from a context point of view, we view the gas bill not as a modernization, but as a new fossil fuel framework. The gas bill, is a full repeal and not an update. And as you'll see, Clause 40 repeals the Gas Act in its entirety and substitutes a wholly new act. That's obviously different from the previous versions of the bill that were publicly consulted on, which were amendment bills. And that has some important cascading effects on other parts of the bill that we raise in our submissions, and some of which we'll highlight here. The purpose of the bill is obviously to promote and facilitate gas facilities, infrastructure, services, investment, and trade, principally an imported LNG gas market that currently doesn't exist in South Africa. And it's important to see it as part of a larger package of new legislation, including the new Upstream Petroleum Resources Development Act, which is still not come into effect, but has been enacted, and also the recent South African National Petroleum Company Bill, which has also gone before Parliament recently, and comments have been made on it, and I think hearings are due on that next week. One of the issues with all three of those is that none of them contain any climate provisions whatsoever. So in brief, just to give you a foreshadow, the Green Connections position is that we advise that the gas bill should be withdrawn in its current form, but that if Parliament proceeds regardless to process and pass the bill, the Green Connection recommends a number of amendments be made, and those recommendations are detailed in the Green Connections comments on the gas bill that were submitted, and which run to many pages. Essentially, then a quick overview of the core issues. The first is that the bill is silent on the climate crisis. It deals with the issue of, or it's based on a bridging fuel premise, in particular for LNG gas and other gas, which is assumed and not tested. The social and economic impact assessment system report that was made available is the wrong report. We'll elaborate a little bit more on that a little later. And that there's a number of protections that are in the current Act that are lost on repeal. We raise concerns relating to power being concentrated in the minister, and also, excuse me, we deal with concerns relating to expropriation being broadened and various safeguards removed. There are also fair process rights, in other words, procedural fairness rights. We have concerns over those rights being weakened. Then in addition, there's concern around consumers being exposed to price risks, and then also issues of planning built on assumptions. Just trying to hide my thumbnails here. Need to be in the way. Right. So on the first concern relating to silent on the climate crisis, this issue has been raised by some of the other presenters yesterday. So first of all, there's no reference whatsoever to the climate crisis or climate issues. The bill makes no mention of the Climate Change Act, the national greenhouse gas emissions trajectory, sectoral emissions targets, carbon budgets, or the just transition. One of the concerns there relates to a binding duty that is currently in operation since March of this year in the Climate Change Act, namely Section 7, subsection 1, which obliges every organ of state to, amongst other things, review and harmonize its laws with the Climate Change Act. The concern is that this bill, which has not yet been made law, clearly has not been reviewed or harmonized to align it with the Climate Change Act obligations. The decisions that matter the most in the climate bill, in the gas bill, include obviously your ministerial determinations, licenses, state guarantees, as well as exemptions, are precisely the kind of decisions that significantly may or will significantly affect the Republic's ability to mitigate against climate change. So that's one of the core concerns. The second concern relates to the assumption of gas as a bridging fuel, which in the bill is assumed and not tested. So the assumption basically treats liquefied natural gas, LNG, as a lower emission bridging fuel to a cleaner economy. That assumption depends entirely on methane leakage across the LNG life cycle, which includes extraction, liquefaction, shipping, regasification, etc. We believe that's risky given the particular climate change risks of LNG gas and methane in particular, which warms or has a climate warming effect that's around 82.5 times more than carbon dioxide over a 20-year period, meaning that even small leaks can erase gases advantage even over things like coal, according to some recent studies. What the bill does is that it contains no requirement to measure, report, verify, or limit methane emissions anywhere. So the result of that, from a risk point of view, is potential decades-long lock-in. Gas licenses can run for up to 25 years. They're renewable, and they allow for full cost recovery. And that's built into a net zero by 2050 economy through our climate change obligations. So obviously, and I think this point was also highlighted in some of the submissions yesterday, you could have licenses running well into, well, even beyond 2050 if they were granted in, for example, 2030. We're also concerned that we don't believe that the gas cliff is an emergency as such. It's been known about for a number of years now, and we see it rather as a concentrated, foreseeable industrial supply issue, and shouldn't be used as a ground for truncating public participation. Our third concern relates to the social and economic impact assessment report that was made available relating to the gas amendment bill. So firstly, that final bill, well, it's indicated as a final CS, but its assessment is against the wrong instrument. It's titled and drafted the Gas Amendment Bill, which is the previous name of the previous iterations of what's now a repeal bill. Its clause numbering doesn't match the bill, etc. And for example, it cites a 1975 expropriation statute that has since been repealed. It's out of date. It predates the Climate Change Act coming into operation and South Africa's second nationally determined constitution contribution under the Paris Agreement. It misrepresents consultation. For example, there's a record as a public concern about whether climate consistency is accommodated in that CS when it is clearly not been. And in the CS, it indicates that it has been addressed. That is detailed in our written submissions for those who want to see it in more detail. And then there's various material omissions in that socio-economic impact assessment system report, such as gas price volatility, stranded asset risk, stranded assets obviously being where facilities, gas to power facilities, infrastructure, etc., are built with long time frames and may find themselves in a world where gas is no longer permitted and are no longer financially viable, or where, for example, renewable energy alternatives become much cheaper and affordable. There's also material emissions include no discussion or mention of methane, and the Green Connection and the communities that it supports. There's no mention of small-scale fishing communities anywhere in the assessment. The fourth concern is that the repeal removes a number of protections without replacing them. Clause 40 deals with savings, in other words, provisions from the previous act that are saved, and it only saves existing licenses and then acts of the energy regulator. Excuse me, nothing else. Two instruments are left exposed by that. The piped gas regulations, which were promulgated in 2007 under the current act in particular, and also possibly the gas rules are not, well, both of them are not expressly saved by the repeal. So what's at risk from that is that, for example, fair administrative action procedures, the right to hearings, participation, notice, etc., reasons become diminished. Provision for hearings on expropriation and compensation are at risk. Decommissioning requirements become also at risk and not clear. Price transparency obligations, bilingual local advertising requirements that are currently in those provisions, they all currently only live there. And if they are not brought forward, then obviously they certainly fall away in respect of the regulations and may well fall away in respect of the rules. The problem also is that it's replaced with the discretion. The bill offers only a discretionary power to remake these protections, which we see as a regulatory gap on commencement of the bill if new rules and new regulations aren't also promulgated to accompany any new bill. Our fifth concern is that the bill concentrates power in the minister. That includes clause 11, which basically provides that any licensed activity may be delicensed. In other words, it can be decided that through the procedure in the Act that certain activities don't need any licensing whatsoever, and there's no stated criteria for that. Clause 28 gives the minister very broad determination power. In other words, the power to make determinations on whether new gas facilities, infrastructure, etc., are required and should be built, etc. And currently, it uses the words after consultation with the regulator, etc. And I think the finance minister, if memory serves correctly. So there's no requirement for concurrence or the independent decision of the regulator, and no requirement built into that for public participation either. Clause 28, subsection 13, introduces an unconstrained power to bind the state to financial commitments, including those that are necessary or expedient. Our particular concern there would be around the word expedient, which we don't think is appropriate. All of these issues are, of course, elaborated upon in our more detailed written summary, written submissions. And then clause 39, which basically gives the minister the power to issue exemptions from the whole act once it's passed, including on open-ended grounds, with no consultations on the issuing of exemptions, no duration limits, no reporting to Parliament. So as a whole, we believe that too much power is being concentrated in the minister with insufficient safeguards. The sixth concern relates to expropriation, where the powers are broadened and certain safeguards are removed. So under the current Gas Act, the power is exercised by the energy regulator. It's triggered by a licensee's request, and only where land is reasonably required. Public hearings with mandatory compensation recommendations are required, and there's also an explicit right to approach court if one is not satisfied with the expropriation decision. Under the gas bill, the power is transferred to the minister, who may then act on his own initiative, doesn't have to wait for a licensee to request, and it can be for any gas facilities with no reasonable threshold attached to it, no prior voluntary acquisition or prescribed compensation procedure. Other presenters raised the issue of free, prior, informed consent for communities in this regard, and traditional communities in particular. And there's no provision for informal or customary land rights under the gas bill. So this is a concern, especially when one, or perhaps highlighted by the state law advisor's own conclusion, as reflected in the memorandum, that the bill may affect land belonging to traditional and Khoisan communities. So yes, expropriation is a concern. A seventh concern, again, an issue that's been touched on by other presenters yesterday in particular, relates to fair process or procedurally fair administrative action, where rights have been materially weakened under this bill. Just some examples that we highlight here include no right of reply in relation to objections. Objectors cannot respond to information filed after the objection period closes. So currently one can object, but the power then allow the further information to be submitted on request by the license applicant, but makes no right of reply for objectors to then respond to that new information. In addition, no consultation is required on things like license renewals, license condition reviews, registrations, all the tariff methodology, and various protections disappear. The duty to furnish reasons, the statutory minimum for advertising applications, as well as the express right to appeal to the High Court. Those all fall away because those are some of the rights that fall within those instruments that I referred to earlier that either aren't or may not be saved, given the savings clause. And then there's also the concern around institutional conflict, where the energy regulator is directed to promote the industry that it regulates, but is also bound by ministerial determinations. And that, of course, then leaves objectives before a decision maker that is not in a position to refuse. So essentially, you have an energy regulator with certain functions and duties and objects, and that, we believe it makes it very difficult for the energy regulator to then refuse any decision in the face of objections. Concern 8 relates to consumers potentially being exposed, well, not potentially, but being exposed to volatile international gas prices. Again, this relates primarily to liquefied natural gas, which is obviously a core component of this new gas bill. The first concern is the narrow regulatory reach of it. So basically, under the bill, the energy regulator is empowered to regulate the licensee margins. In other words, those parts of the tariffs and prices that relate to profit, etc., and recovery of costs, but not the landed cost of the imported gas, which, as we indicate, is volatile and set on world markets. So that's a massive input fee into what will affect the cost that is ultimately paid by consumers, and that's because the system would obviously be designed on a cost pass-through basis. So, in other words, gas to power is intended to be generated from the use of LNG, and then the cost is transmitted to every electricity consumer, which would also include low-income and previously disadvantaged households who can ill afford to pay for high electricity costs or higher than necessary electricity costs. And then again, transparency is rolled back. So existing price transparency protections are repealed. The pricing methodology is left to rules that the regulator may make and need never be published in draft for comment. So basically, the issue is that LNG trades at international prices and that even domestic production, so that would be upstream production, would not shield consumers from potential global price shocks. The current slide here just gives you an indication of the LNG benchmark price from 2020 to 2026. And that's really just an illustration of how the price has started out at $4.37 per the applicable unit, reached $33 when the Russian-Ukraine conflict started in earnest, then went back down and stabilized for a while before soaring back to about $21 per indicated unit due to the Middle East conflict, the Israel and US Iran war. Our final concern relates to planning built on assumptions rather than evidence. We believe that the cart has been put before the horse. Provision is made for obviously the gas master plan, but without a current integrated energy plan on terms of reference for the gas master plan that presuppose gas expansion. The integrated energy plan is obviously brought into effect by Section 6 of the National Energy Act. That was not brought into operation for many years. The face of litigation was...
Can we please move towards conclusion as the time is up?
No problem. But essentially, there's no current integrated energy plan. Another concern is there's no stress testing, no requirement to quantify emissions or to test scenarios in which gas demand does not grow. And then there's also discretionary decommissioning requirements relating to decommissioning at the end of life, rehabilitation and financial provisions are all left wholly to discretion, precisely at the time when stranded risks become a public liability. The final slide just deals with some additional issues of concern, which, given that my time is up, I'll just pass on. And just to reiterate, the Green Connection's position is that the gas bill should be withdrawn, but that if Parliament proceeds nonetheless, the TGC Green Connection has made a number of recommendations in its written comments that it believes should be considered and addressed. Thank you very much.
Thank you very much once again for another comprehensive presentation. We will now move on to take a presentation from Minerals Council, and then we'll move to seeking questions from the presentations that have already been made by the FW de Klerk Foundation, Green Connect, and lastly, the Minerals Council, which is about to present now. Can they please be granted co-hosting rights so that they can be able to fly their presentation?
Minerals Council, can you please indicate who must I give co-hosting rights to?
You can give it to Ernst, but I'll do the introductory remarks. Very
All right, sir. Sure, sir.
Yeah. So let me just, can I go for it? And perhaps just greet the chair of the Portfolio Committee on Electricity and Energy. And to also really thank you for, as a Portfolio Committee, for giving us an opportunity as the Minerals Council to make a submission foremost, and as well as to just do our presentation. The reason I showed my face is just to show that this is not AI. This is a real person who's talking here, and then I'll just switch off my camera. As I mentioned, you'll notice, Chair and committee members, that our submission was mainly focused on hydrogen. And this is because we believe that the hydrogen value chain represents one of the most significant economic and industrial opportunities available for South Africa or to South Africa today. And there are three reasons, really, we believe so. The first one is that hydrogen is not merely an energy source. It is an entire industrial ecosystem which encompasses renewable energy, electrolyzers, fuel cells, storage, transport, green ammonia, right up to the export infrastructure. So this is an entire industrial complex. And South Africa has a competitive advantage across many of these value chain segments, including a world-class renewable energy resource. And the second reason, maybe before I go to the second reason, let's remember as well that the hydrogen value chain, one of the most important inputs is the PGMs, platinum group metals, which as a country, we possess about 75% of the world's PGM reserves. And the PGMs are a critical input into the fuel cells technology. The second reason we believe that the hydrogen value chain presents a significant economic and industrial opportunity for South Africa is the fact that if we as a country invest in hydrogen-related research and development, this creates opportunities beyond scientific discovery. It supports industrialization, and as a country, remember, we have deindustrialized. We have been in a deindustrialization journey for the past 2 decades. So the hydrogen value chain will support industrialization, it will support localization, beneficiation, job creation, as well as export growth. But also it will support and strengthen various sectors and industries within our economy, such as mining, refining, manufacturing, as well as power generation. And the third reason, which is really the final reason, is that we believe in the hydrogen value chain because it presents a new growth frontier for South Africa. Let us remember, we have been growing at an average of 1.1% from 2009 right up to 2025. Before then, we had been growing at between 1994 and 2008. As a country, we had been growing at a average rate of 3.6%. So post the global financial crisis of 2008, our growth has been far lower. And as South Africans, we've been getting poorer. And so we believe that the hydrogen value chain presents a new growth frontier for South Africa. And this is basically supported by the Hydrogen Society roadmap, which was published, also the Green Hydrogen Commercialization Strategy, and the Hydrogen Value Valley Initiative, which supports the key industrial hubs from Johannesburg right up to Durban, Richards Bay area. So these initiatives, for us, they aim to position South Africa as a producer, as a user, as well as an exporter of green hydrogen. So Chair, our view as a Minerals Council is that greater investment in the hydrogen value chain is an investment in South Africa's future competitiveness. not only in job creation, but also in general economic growth, infrastructure growth as a country. So thank you, Chair, for that. Those were our opening remarks. I will now hand over to my colleague, Ernst, to just get to the material of our submission. Thank you, Chair.
Thank you, Bongani. Thank you very much, Chair, ladies and gentlemen of the committee, for the opportunity to speak to you today about the Mineral Council submissions on the gas bill. As Bongani illustrated through his opening remarks, the focus of the Mineral Council submission is on the impact which the gas bill could play on the development of South Africa's budding hydrogen sector, not just, of course, green hydrogen, although that is a significant focus of the government's Just Energy Transition Investment Plan processes, with a 319 billion rand earmarked for the development of the sector, as will be addressed in greater detail at President Ramaphosa's summit in September. But then also understanding how it can be used to drive related sectors, as Bongani also mentioned. The presentation, I'm assuming, will be shared afterwards, so I'm not going to spend any more time talking about the green hydrogen opportunity or the hydrogen opportunity. The key concern that the Minerals Council and its members has, ladies and gentlemen, and as was set out in the submissions that was presented to the committee and briefly summarized in this presentation, is that the bill and eventually the act, although in due course we will as a country require a dedicated act that regulates hydrogen and the production, distribution, transmission, storage, trade of hydrogen in due course, the development of such a legal instrument will take time, and we should not lose out on the opportunity that is presented to the country at this point in time to produce green hydrogen as a result of all the energy sources that we have at our disposal, and then to become active participants in the global economy in this regard, because we need to wait for an act of parliament to be developed and then go through the parliamentary processes and be enacted. And we think that the gas bill in its current form, if it is adequately amended and supplemented, can suitably provide the necessary transitional mechanisms to enable the initial establishment and regulation of South Africa's hydrogen sector, and in due course then those provisions can be replaced by a dedicated Hydrogen Act. The reason why we think it is necessary to specifically address hydrogen in the gas bill and for the bill to be amended is because of the unique properties of hydrogen, both from a physical perspective. If we think about hydrogen, the requirements that the chemical has in the transportation and the production and transportation, distribution of the chemical of the molecules themselves, but also in relation to the larger hydrogen value chain. If we think about it from the perspective of production through to transmission, distribution, trade, and eventual use thereof. And there are certain changes that can be introduced to the bill to adequately cater for this as a transitional mechanism. Now, everybody on this in this meeting is very familiar with the international best practice in this regard, which suggests that laws and create legal frameworks which are conducive towards stimulating economic growth and promoting better domestic and foreign investment if they are focused on three main things. First is to prescribe duties and vest rights in persons who are regulated under the Act in a way that is clear, easy to understand. At this point in time, as we'll briefly touch on in a second, the law doesn't clearly regulate hydrogen and the participants in the hydrogen ecosystem, and for that reason, this will act as an impediment to the development of the hydrogen sector. Second, it must prescribe processes that give rise to fair and predictable outcomes. And then finally, it must clearly set out the role of the regulator, both as the administrator of the Act as well as the enforcer of its mechanisms. The first thing we should then point out, and as the Minerals Council and its members have pointed out in the submission, is the fact that it is unclear the extent to which hydrogen as a gas is regulated under the Act. Per the definition, it refers to hydrocarbons, but then this contradicts to some extent the information provided in the explanatory memorandum and the definition, which refers to hydrocarbon-rich substance. In the explanatory memorandum, ladies and gentlemen, the the Department of Electricity and Energy sets out that one of the key reasons for developing the bill is to ensure that the bill reflects changes to the economy, the introduction of renewable gases, and then, of course, including hydrogen-rich gases. We think that this can be addressed easily enough by specifically referring to hydrogen in the definition of the gas. In addition, we think that the bill should also be reviewed in the context of the need to specifically not only refer to the transmission, distribution, storage, and trade of hydrogen of gases, as is currently envisaged under Clause 10 of the Act that deals specifically with licensing processes, but also pay due regard to the production of hydrogen. Of course, different from the other gases which are regulated under the Act, the hydrocarbons specifically, the production processes that underpin the development of hydrogen are different. For example, as Bongani referred to, the development of specific facilities based on the use of electrolyzers and the electrolysis process, the dependency on access to water, the dependency on access to electricity. Electrolyzers, for example, ladies and gentlemen, are not currently regulated extensively in South Africa. They sit at the intersection between the gas legal regime and the electricity legal regime. And for foreign investors wanting to invest in the production of green hydrogen or the development of green hydrogen production facilities in South Africa, that is a key question for them, how that is specifically regulated. A second thing that flows from this, for example, is dealing with distribution. Under the current definition in the Act of Distribution, it refers to facilities that are able to transport gases at pressures of between 2 to 15 bar. If this is compared to what we see in the hydrogen space, on the road distribution networks, hydrogen is transported at between 180 and 200 bar. From a pipeline perspective, between 30 and 100 bar. So simply at this point in time, the transmission and distribution of hydrogen falls outside the scope of the Act and is therefore not regulated. So those are the types of factors that need to be considered in greater detail. As we touched on then just now, infrastructure and investment is a key component, and we would suggest that the portfolio committee consider reviewing the Act in the context of the whole hydrogen life cycle, starting from production, transmission, distribution, storage, and then also trade, to ensure that the mechanisms created under the Act, which regulate the other gases, are suitably adapted and amended to also cater for circumstances that apply to hydrogen as a gas. Included in this then would also be the need to provide for the intersection of hydrogen production and hydrogen as a gas with other elements that are regulated under other pieces of law. For example, renewable electricity, access to water, safety and security settings, and the like. Slightly conscious of time, so I'm going to jump onto the penultimate slide here. The last thing to also bear in mind, and this is something, ladies and gentlemen, that we in South Africa are very familiar with in the context of electricity regulation, in the context of mineral regulation, and then also under the Upstream Petroleum Resources Development Act, if we think about petroleum resources and the exploitation thereof, the need for proper cross-sectoral coordination. The hydrogen sector is quintessentially dependent, as I mentioned on the previous slide, on access to sustainable energy, on access to water resources, on infrastructure that allows for the safe transport of the hydrogen that has been produced. It would be important to ensure that in the first instance that the provisions under the Act which empower the minister to publish regulations or the gas regulator, NERSA, to publish rules, that those clauses in the bill and then eventually sections in the Act specifically empower these government stakeholders to publish rules and regulations that address hydrogen, specifically how hydrogen should be safely transported, what is expected, and then also in relation to the impact from a global perspective, the need for proper standardization and certification processes, to the extent that South Africa wants to ensure that the hydrogen which is produced in South Africa meets global requirements, how specifically South Africa deals with standard setting processes. In conclusion, ladies and gentlemen, we think that the Act, or the bill rather, apologies, presents South Africa with an exceptional opportunity to introduce mechanisms that would act as catalysts for the establishment of a robust regime to regulate hydrogen then amongst other gases. It's a credible mechanism that we should be pursuing based on expert-led growth and domestic market development processes, but fundamentally to ensure that it's based on a process that promotes regulatory certainty, to ensure that domestic producers, domestic participants, and international participants have a proper sense of the rights they vest in and obligations which are imposed on them as they are participants in the green hydrogen, or in the hydrogen value chain, rather. The bill should do this now. We shouldn't wait for independent hydrogen legislation to be developed and promulgated. This could take a number of years, and we will further lose out on the opportunity that is being capitalized on by our neighboring countries such as Namibia or other African countries such as Kenya, Morocco, Mauritania, Egypt, all members of the Global Green Hydrogen Alliance. Finally, just in conclusion, of course, it goes without saying that the Minerals Council of South Africa and its members are fully supportive of this process, and to the extent that we can provide any additional support to the parliamentary committee or to the drafting processes, we would welcome the opportunity to propose wording, etc., on how the provisions under the bill could be further bolstered in order to create a robust regulatory regime for the production of hydrogen. Thank you.
Thank you very much for that presentation, Minerals Council. We will now take clarity seeking questions for all the three presentations that we have received. Please, honorable members, do indicate who your question is directed to, and maybe please get all the questions and then get the responses after. I saw in the other session, stakeholders were tempted to respond directly to the question. Honorable Drink. Honorable Drink, the platform is yours, and then afterwards we'll take Honorable Nkosi and then Honorable Ntabeleng.
Thank you. Thank you, Chair. Chair, I think firstly to the FW de Klerk Foundation, the first question is what in your view would be the consequences if clause 15 subsection 3 with respect to imperatives is not amended to make it more definitive? You've obviously indicated that it's not very defined or clear, the word imperatives. What would the consequences be if it's not amended? And then on governance, recommended preservation of NERSA's independent application of the law. I see that you make no comment on the capacitation of NERSA to ensure that they are able to take on this added task. What, in your view, would be required for NERSA to take on the added task in terms of NERSA's independent application of the law? Then, with regards to Green Connection, Green Connection indicated that they do not believe that the presenter indicated that they do not believe that we actually face a gas cliff. And what is needed is a public participation process, which may be a better route to deal with shortages, if I understood you correctly. So a simple question here then, are all of the different sectors incorrect in presenting that we actually currently do face a gas cliff? And what would Green Connect kind of flesh out what their solution would be to to dealing with the current possible gas shortages that some 98% of the 99% of the presenters have indicated we are facing? What would your solution be to actually deal with the looming gas shortages? And then just here on the Minerals Council, I think I agree that that hydrogen is a gas that ought to be incorporated within the gas bill, and it shouldn't sit on the fringes or seem to be excluded. particularly with regards to the legislation on storage, transportation, water regulation, water resources, and desalination plants. But perhaps just with regards to just this infrastructure that is required to see South Africa as a key hydrogen gas developer and exporter. What are the timeframes to put all of that infrastructure in place? Noting that we have countries like Morocco on the continent, and other countries that are fast moving towards developing the hydrogen economy. What is the timeframes do you envisage that South Africa actually needs to have, and how can these be incorporated also within the bill? Thank you.
Honorable Goldsmith.
Thank you very much, Honorable Chair. I will also, Honorable Chair, like to welcome all the comments, the presentations today. Chair, I have a question to FW.
Yes, Honorable Goldsmith.
The Clerk Foundation. In paragraph
Honorable Goldsmith, your line is a bit bad. I don't know if you can do anything to make it better.
38.1, transformation object with a non-racial. Yeah, where?
Yeah, you're breaking, Mr. Nkosi.
Okay. No, I'll probably try to ask again the question. Let me just change the gadget.
But that was much better now.
Yeah, can you hear me now?
Yes, sir.
Okay. Yes, no, I just have a question to FW, the Clerk Foundation. It's on I think there is paragraph 38.1. You recommended replacing the race-based transformation object with a non-racial and needs-based model focus on socio-economic indicators, while the triple BEE remains an act and a binding law. So I just wanted to check how practically should NASA evaluate and balance these proposed non-racial criteria alongside the mandatory requirements of the Section 10 of the BEEE Act when assessing the license applications. That is my question, Chair. I don't know if were you able to get it?
Yes, you are now clear.
Okay, thank you.
Thank you, Honorable Goldsmith. Honorable Nxabeleng.
Thanks a lot, Chair, as well as the presenters from the morning until now. Good morning, everyone. I think our contribution is first one. Let's go to the issue of the green connection in their belief that we might not even need gas in the near future because of the introduction or the actually rapid development of green energy, your solar and wind. Is there anything that is based on this belief? Because we are of the view, that is why there is an amendment on this gas bill, that we need gas as an alternative to actually offset some of the carbon crisis that has actually plagued the world, not necessarily just South Africa, but gas plays an alternative role in substituting part of the offsetting of the carbon. But when we hear views that says that, gas might not even be a necessity, when South Africa is putting up so much of effort and energy into the gas pipeline, into the gas economy, into the gas infrastructure, it's worrisome. So I just wanted to know what is the rationale behind that thinking. And I know it's based on the fact that we're trying to go towards a neutral, what do you call it, net zero. But the net zero objective in South Africa, and I can be realistic about it, that we need gas, we would need nuclear to achieve a full-on net zero. And alternatives in terms of solar as well as wind on their own, unfortunately, scientifically, it's not possible at this stage. Even in the near future, we will not be able to run industries if we were to plan policy along that line. So I just wanted to understand, what is the rationale for being against gas? That's question number one on grid connection. Secondary to it is, I think on the question towards FW de Klerk is to ask this particular, because I think the presentation was primarily presented around the concern about broad-based Black economic empowerment, or BEE in a simpler term, Black economic empowerment. Is there any reason the de Klerk Foundation believes that Black economic empowerment should not be a primary component? What is the reasons behind this objection that we should still include BEE? Because, historically, and I think it's a very strangely amazed that the de Klerk Foundation would come out in opposition to BEE when we all know that previously and historically, South African white community in South Africa, including the honorary, the former President de Klerk himself, was a beneficiary of white economic empowerment. And if it wasn't for that reason, we would not be having the current industries that exist. So what is this objection? And I'm asking this from a public representative point of view. There seems to be an obsession to say Black people do not deserve empowerment. And as a result, Black economic empowerment should be done away with. And the reasons are used usually speak about the fact that BEE was abused in the past, and BEE excludes other racial denominations. The question of poverty in South Africa is racially Black, majority Black. And it's completely posed on the South African context of saying Black people are the most suffering in our economy. So when we say we don't want to have a gas bill that talks to Black economic empowerment, what are we then doing in terms of really undoing the racial inequality and the economic imbalance that exists till today? The highest level of unemployment is Black people, the youth in majority as well. So I'm a bit perturbed on that one. And I just want to understand, because this is presented by Ismail, who is a Black person himself, but saying that they, as the de Klerk Foundation, are extremely against Black economic empowerment. Moving on to the other question with the Minerals Council, I think we appreciate the presentation on the emphasis on the hydrogen. More than anything is to say that I think maybe the much more deeper insight should be done on how should this bill fully accommodate the hydrogen gas economy and how hydrogen can be utilized, including the fact that we have a huge mineral complex that has already been identified, the platinum reefs that we have and we have in abundance in the world, in South Africa, and how this hydrogen economy can be activated to benefit our people fully, to revitalize the mining industrial complex properly, and to create what we used to talk about then, which is beneficiation, using hydrogen, using critical minerals such as your platinum, etc., and the current, battery and storage technology that we need to start leaping forward into. So I just wanted to hear much more on what is needed to be done into the bill so that the bill reflects properly, because you're quite right. Currently, the gas emphasis is not primarily on hydrogen. It speaks about pipe gas, which is LNG, as well as the other lower grade LPG, etc. of gas, on that basis. But the view that there was another view that said that I don't think we need this legislative amendment. I would say it's a bit amiss, because we really have to have a legislative amendment on the basis that the current gas infrastructure is not covered within the bill, and that is why we're not having economic development. Just in conclusion, Chair, the last point is relating to the powers of the minister. Everybody has raised the concern that I think the minister is overly empowered on this whole thing. And I think we need to narrow down on that one to say which areas where there is a concern about the powers minister should we look into in order for the bill to be adjusted. And that is my closing remark. Thank you so much and much appreciation.
Thank you. So we're going to take responses from FWD Care Foundation first, and then Green Net, and then afterwards we'll take Minerals Council in that order.
Thank you, Chairperson, and thank you, Honorable Thring, for the question. You're quite right that there would be consequences if imperatives, quote unquote, remains undefined. I think the immediate consequence then is that you'd have legal and regulatory uncertainty, because applicants won't know whether an imperative is merely a policy consideration, whether it's a minimum requirement, or effectively a ministerial instruction. Now, NERSA may treat it as a binding one in one application, but might give it less weight in another. And so this then creates some form of inconsistency in licensing decisions, and it increases the risk that NERSA's statutory discretion is improperly fettered. It may also lead to PAJA review proceedings and delays and reduced investor confidence. And so I think our concern, therefore, is not that ministerial policy is illegitimate, but really that the bill should state its legal weight clearly. I would say then that the safest formulation is that an imperative is a relevant published policy consideration that NERSA must consider, but which cannot dictate an outcome contrary to the bill's safety and technical and environment requirements. And then on capacitation, Honorable Member, I think it's a very important point. Yes, the bill gives NERSA additional responsibilities involving new technologies and expanded licensing and registration and third-party access and so forth. And so NERSA will therefore require, I think, more than just a legal mandate. It needs a properly costed implementation plan, predictable funding, additional engineers, economists, competition specialists, lawyers, investigators, and so forth. And so we recommend that before finalizing the bill, the committee then requires the department and NERSA to provide a workload assessment, a proper budget, a recruitment timetable, and a schedule for producing the necessary rules. Otherwise, we end up in a situation where Parliament may enact a strong framework that the regulator lacks the people and the resources to implement it effectively. And then to answer the other questions, thank you to Honorable Nkosi for the question posed. To answer your question, I think while the BBBE Act does remain in force, NERSA cannot disregard or replace it, yes. Section 10 requires NERSA, when determining licensing criteria, to apply the relevant BBBE code. And that must remain the legal baseline. We're not opposing that. So our proposal is therefore not that NERSA should choose between these two competing systems, but rather that it should operate in two stages. That firstly, NERSA must verify compliance with the BBBE Act and any other applicable lawful code. And then secondly, when considering the broader public interest and the transformation outcomes of an application, it must then examine these measurable factors that I mentioned, like skills created and sustainable employment, things like participation by women, young people, persons with disabilities. I think those additional indicators should supplement the statutory BBBE assessment, but they cannot be used by NERSA to cancel or contradict or invent any sort of exemption away from Section 10. And they should also not become a second unpublished scorecard. Parliament or lawful regulations should specify the criteria and the evidence and the weighting clearly so that applicants know in advance what is required, and so that double counting then is avoided. There could be conflict, but if conflict arises, the BBBE Act must prevail unless it is amended or a lawful exemption or deviation is granted through a mechanism in Section 10. But our long-term preference is an agenda towards this need-based model. But under the law as it presently stands, NERSA, yes, must comply with the BBBE Act, while also asking a wider question of, did this project actually create real and sustainable economic opportunities for disadvantaged South Africans? And then to address the question posed by Honorable Chabeleng, Thank you, Honourable Member. But let me answer that concern directly. The FW de Klerk Foundation does not believe that Black South Africans do not deserve empowerment. Apartheid was, in substance, a system of legally enforced white economic empowerment. You are absolutely correct. It excluded Black South Africans from land and capital and education and skill positions and business opportunities. And yes, white South Africans had benefited from that system. And now meaningful redress is both a constitutional and a moral obligation. So we're not asking Parliament to remove transformation or Black participation from the gas bill. As I said earlier, the BBB Act remains binding, and our submission expressly accepts that NERSA must apply it. But our concern is a bit narrower than that. It's that Clause 2H emphasizes companies, quote unquote, owned or controlled by Black people, whereas the BBB Act itself understands empowerment more broadly than that. It includes ownership, but it also includes management and skills and workers and women and young people, persons with disabilities and so forth. So when we have this capital-intensive industry, a nominal ownership transaction financed by heavy debt may actually leave Black beneficiaries with little lasting value. On the other hand, training Black engineers and artisans and financing Black-owned suppliers and creating sustainable township and rural enterprises, that can actually assist these communities much better and really be better for all of us in South Africa. And so therefore we ask that Parliament measure the substance of transformation, not just this formal component of it. And therefore we come up with this needs-based indicators that wouldn't ignore apartheid's racial consequences, because poverty and unemployment and spatial exclusion are, as you said, Honourable Chebeleng, heavily concentrated among Black South Africans. Black South Africans would remain the principal beneficiaries under our needs-based approach. The purpose really is to ensure that empowerment actually reaches the broad majority rather than to just repeat it to benefit any narrow group. So if the committee doesn't support replacing Clause 2H, our minimum recommendation would really be to broaden it so that it reflects the full meaning of BBBE, requires measurable outcomes, prevents things like fronting, and then also periodically evaluates who actually benefited. So our objection, lastly, is not against Black empowerment. It's actually to empowerment that exists on paper, but fails to change Black South African lives. That's what we're objecting against. Thank you.
Thank you. Green energy. Sorry, green.
Green connection.
Green connection, yes. Green connection. Are there any responses you'd like to provide?
Yes, thank you, Honourable Chair. Yeah, the first query was by the Honourable Thring, querying whether the Green Connection believes that we don't face a gas cliff, and made reference to various sectors who all agree that we do face a gas cliff and what the solution would be. Yeah, to state the Green Connection's position as clearly as possible, the position is that the glass cliff narrative does not justify the legislative architecture that's being proposed, which is essentially through this gas bill an expanded establishment of gas facilities, trade in gas, transport of gas, etc., etc. So basically establishing or creating a gas market for a demand for gas that doesn't currently exist as such, especially when one speaks about liquefied natural gas, and that within the context of other legislative developments such as the Upstream Petroleum Resources Development Act, which also seeks to promote accelerated oil and gas expansion offshore, not to mention other provisions that relate to onshore gas such as fracking. So basically, the Green Connection does not dispute that the decline of the Panda and Tamani fields presents a real supply problem, especially for the large inland industrial gas users, many of which use it as a feedstock. But essentially, the point that we made was first in relation to the determination-making power being on one of the bases for the minister being empowered to make determinations relating to new gas facilities, infrastructure, etc., was in the event of an emergency. So the point that we were making there was that the decline in those fields has been foreseeable for well over a decade. And the department's own SEAS report records that supply was expected to be constrained from about 2025 onwards. So with those long foreseen supply constraints, the submission there is that they shouldn't be seen as an emergency that requires those extraordinary powers to be exercised with truncated or absent public participation, given that there's no provision for that relating to the determination-making powers. The second point, just to emphasize, and we do elaborate upon these in the written comments, is that in relation to the gas cliff, responding to a time-limited industrial supply constraint by procuring imported liquefied natural gas on a long-term take-or-pay terms, backed by state guarantees, converts that constraint into a multi-decade national fiscal price and emissions commitment that would ultimately be borne by the public. The Green Connection believes that the proportionate response would be a managed transition for the affected industrial users through things like electrification, energy efficiency, and alternative feedstocks, which we're not saying we have all the answers at hand or the technical reports as part of the submission, but we believe that needs to be assessed transparently against what alternatives may exist. So that's the response on the gas cliff issue. The second issue was raised by the Honourable Prince Nchabaleng, and that related to the issue of gas perhaps not being needed soon because of renewables, speaking about gas offsetting carbon emissions, and clearing, obviously, why so much effort is being put into gas, and ultimately baked down to what is the rationale for being against gas. So the Green Connection's response to that is there's a few points to be made. Firstly, the emissions profile of liquefied natural gas, which a large part of this act seeks to enable, is materially worse than pipeline gas, which is obviously your typical natural gas that's transported in a gaseous state through pipelines to end users, which has an entirely different process to LNG gas. So with LNG gas, the emissions are often systematically understated when it comes to, by reference to combustion emissions alone, whereas greenhouse gases are emitted at every stage of the LNG value chain. So that goes from upstream extraction and processing, including venting, flaring, fugitive releases, during liquefaction, which is highly energy intensive, during shipping, during regasification, and then obviously onward transmission, storage, distribution. So at each stage, methane gas may leak. And as mentioned earlier, fossil methane is a potent short-lived climate forcer. So that's been assessed or estimated by the International Panel on Climate Change, AR6 working group, as having a global warming potential of 82.5 times that of carbon dioxide over a 20-year period, and around 30 times more than that of carbon dioxide over a 100-year period. So the consequence is that comparatively small leakage rates are sufficient to erode and perhaps eliminate any claimed advantage over coal. And peer review research published in 2024, some of which we refer to in our written comments, concluded that once upstream, midstream, and midstream methane emissions are properly accounted for on a 20-year basis, the life cycle greenhouse gas footprint of exported LNG gas may exceed that of coal. So there's certainly questions relating to whether liquefied natural gas can offset the carbon emissions as intended. And the next point that we make is that while establishing a national regulatory framework for an LNG gas-based industry, the concern is that the gas bill remains silent on the single largest non-CO2 climate risk that the industry presents, and obviously that's again methane gas emissions. So the third concern is the asset lifetimes contemplated in the bill are arguably irreconcilable with our net zero commitment. So, for example, Clause 19 permits operating service or trading licenses to be issued for up to 25 years. taking into consideration expressly time required to achieve a return on investment. Then there's clauses for permit renewals, for exclusivity, etc., etc. So the concern there is that taken together, these provisions build a statutory expectation of full cost recovery over a multi-decade horizon into infrastructure that we might, into infrastructure that the Republic has committed to operating in a net zero economy by 2050. And so, for example, licenses issued in 2029 for the maximum permitted term would run to 2054. And that raises the concerns, for example, around the issues of, or the issue of stranded assets being in place. When it comes to renewables, or the argument that renewable energy sources can't provide, or can't provide a base load for electricity generation. Obviously, that falls more under the electricity point of view, but certainly that is contested by various experts who believe that base load can be met through a combination of renewable energy and various storage opportunities, the cost of which has come down progressively over the last 10 to 15 years, making it the most affordable form of electrification available. So those are the Green Connections responses to the questions. Thank you.
Thank you for the opening round, Council.
Thank you, Chair. I think the question by Honorable Thring as well as Honorable Chabeleng almost has the same answer, but maybe this is how I can answer the question regarding time frames. We have not thought about time frames per se, but we do believe that government can play a critical role in catalyzing as well as de-risking the entire hydrogen value chain, from generation right up to the infrastructure that is required. And they can use this mechanism that has been tried and tested in this country, which is a public procurement program. And basically, this is similar to the Renewable Energy Independent Power Producer Procurement Program. That, in our view, can really help to catalyze the hydrogen economy or the hydrogen value chain. And we've seen this, that Namibia has used the same mechanism. It has helped to de-risk projects in that value chain, and we believe that South Africa can actually do the same, especially because we are really experts in this. Remember, our program, our REAP program, is one of the most notable and most successful program, is among the most successful and most innovative program globally. So that's where I'll leave it, Chair. Maybe Ernst, would you like to add?
Thank you, Pongani. Perhaps just 3 quick points in response to the queries. The first is Clause 28 of the bill already empowers the minister to publish determinations for new gas facilities, services to supply, or gas supply, as Bongani mentioned, akin to the mechanism under Section 34 of the Electricity Regulation Act, which would enable private sector participants to work with the Department of Electricity and Energy, as they are doing in the context of the REAP and the BEST programs, to develop the required infrastructure. So the mechanism is already envisaged there. It just needs to be updated and amended to specifically provide for circumstances that, for example, regulate the production of hydrogen and the transportation and storage of hydrogen. Second point I think I should make, just in response to the first comment in relation to Morocco. Of course, Morocco's got great infrastructure that ensures that piped hydrocarbons are transported into Spain and then across Europe. From a South African perspective, we must bear in mind that hydrogen isn't only necessary in the context of piped gas that needs to be transported, say, from the Northern Cape Province across to Gauteng, but that often from a shipping perspective, it can be used as a green fuel for ships. So we need to take a look at the models that they're pursuing in Lüderitz, in Namibia, for example, and also in the context of the production of green fertilizer, for example. It can have a significant impact on agricultural processes. Conversations with Meta Matlari and her team at Matlako, where they are pursuing some of the first green hydrogen production projects in South Africa. They can explain to you exactly what is necessary from an infrastructure perspective. So I think that there are different types of infrastructure that needs to be developed. It's not just transmission or distribution, but for example, in relation to storage and production as well, where there are quick wins, there are low-hanging fruit for the country there. And the last question in relation to the different sections of the bill that would need to be supplemented, our sense is that it would need to take a comprehensive top to bottom review, starting, for example, with tweaks to the definition of gas, tweaks to the definition of distribution to take into consideration the hydrogen-specific physical characteristics, the introduction of a production license, for example, all the way through to the rules and regulations, empowerment provisions at the end to ensure that, for example, the minister or nurse, depending on the most appropriate authority, is able to publish rules relating to standards for the certification of hydrogen or safety-related standards. Thank you very much for the opportunity, ladies and gentlemen.
Thank you. I think we have come to the end of the seeking questions. We will now go on to take the 4 presentations which we have clubbed together because there is one stakeholder that is no longer going to be presenting. So we are going to be starting with BBC. Can you please have the individual who will present indicate who will be presenting on behalf of BBC so that they can be given co-hosting rights? Madam Chabeleng is certainly at the hand.
Oh, it's a legacy hand, Chair.
Okay. Are we getting the individual from BBC?
BBC?
Okay. Perhaps you can take the next one and then they can come after. It's Priasa on the platform so that we take them instead. And then they can come afterwards.
Mr. Chavalaro?
Yes, I'm on the platform. Thank you.
You were given co-hosting rights as well, Mr. Chavalaro?
All right. Let me bring my presentation up.
I would like to remind our presenters that there's been allocated 20 minutes each for the presentation.
Right. Thank you very much, Chair and members of the committee, for the opportunity for the Fuels Industry Association to present on the gas bill. We have submitted written comments, and yesterday we've also submitted slides with regards to today's meeting. And based on what I've heard this morning, I will not repeat some of the points that have been raised by other organizations. I'll just Sorry, just want to go back to my first slide. I'll just focus mainly on the issues that are like specific interest to our association, and also in the interest of time, I've got only 20 minutes, so I'll move very quickly. So just by way of background, the Fuels Industry Association is a trade body that represents participants in the downstream liquid fuels industry and the value chain, the energy value chain. We represent members on the issues of non-competitive issues and issues relating to secure fuel industry that supports South Africa economic growth, energy security, and regulatory certainty. One of our role is exactly what we are doing today, which is to provide input into legislations and regulation and any draft public policy that require comments. I think I just want to say right up front that the Fuels Industry Association of South Africa welcomes the gas bill, and we in principle support the objective for creating a modern framework for the orderly development of the gas industry. We do believe that the bill can strengthen the energy security, attract investment, and support industrial growth, and also contribute to the energy transition. Our comments will focus mainly on issues of regulatory nature, like particularly regulatory certainty, competitive markets, proportionate compliance and investment protection, and efficient infrastructure development. So we believe that the liquefied petroleum gas should be explicitly recognized alongside natural gas as a strategic component of South Africa's future energy mix. Where the bill introduces new regulatory powers or obligation, implementation should be transparent, based on evidence, and proportionate and subject to meaningful consultation. So let me just start with some of the key issues that we would like to bring it to the attention of the committee. The first issue, it relates to definition of gas in the bill. The definition itself, it includes natural gas, LNG, CNG, and regasified LPG or liquefied petroleum gas, and other gases. So as you probably know that, there are certain LPG activities or liquefied petroleum gas activities that could fall within the bill's regulatory framework. Emphasis that could, because we see clarity in terms of the approach of legislators, in terms of what is the intention when it comes to LPG and the gas bill. So our comment or concern, it relates particularly on the boundary between the liquefied petroleum gas regulated under the Petroleum Products Act. And what is being proposed here under the gas bill, that the LPG or regasified LPG regulated under the gas bill, we believe that there must be clarity so that we avoid having duplication or having multiple regulators really trying to regulate the same industry. I'm sure you are probably aware that currently the liquefied petroleum gas is regulated under the Petroleum Products Act, under the DMPR, and it also in the definition of Petroleum Products Act. And we picked up that it's also here under regasified LPG also brought into the gas bill. So we believe that there should be explicit regulatory clarity on the application of the bill to the LPG and the interaction between the Gas Act and the Petroleum Products Act frameworks. So the important thing is that, I mean, the definition needs to be very clear as far as LPG is concerned. Then I will just also touch on the issue that is also in our submission that we have made. The issue on clause 4 that relates to tariffs and maximum prices. I think the key provision here is that NESA regulates tariffs and maximum prices where competition is inadequate. So currently the way it works is that, I mean, the maximum prices in the LPG in terms of Petroleum Products Act are regulated by DMPR as the regulator. And however, with this inclusion of the LPG in the Gas Act, the gas bill, this is probably or is likely to change. So the impact on the industry is that, I mean, it will affect the pricing, the current way of pricing during the time when this is fully, being implemented, and potentially the economics of imported gas. I'm sure the committees are aware that, I mean, we are largely dependent on imported liquefied petroleum gas. So I think the issue of concern is that, I mean, should we be subjected to this bill? It will be very important that, I mean, the tariff themselves that are predictable to ensure for long-term planning in terms of infrastructure investment. Tariffs themselves or tariff methodologies, I mean, are essential in providing investors with a reasonable certainty and also the opportunity to recover efficient costs and earn a fair return. So our recommendation here, it will be to support, a cost-reflective pricing that recognizes the international benchmarks, the freight, the forex terminal cost, storage, and working capital, and all the related costs that are attributed to the importation of LPG to largely ensure that we continuously supply the market and ensure security of supply. So all those costs needs to be recognized if the LPG is to be subjected to the gas bill as it's currently suggested. Then clause 4, again, it deals with the issue of competition, inadequate competition. Again, here the maximum price regulation applies where there is inadequate competition. That is kind of the starting point. The classification itself of a market as insufficient, where insufficient competition takes place, could trigger price regulation. But the comment that we have here is that the criteria and relevant geographic or product market must be transparent. A market may appear sometimes concentrated because of infrastructure investment, which is largely shared because it's capital intensive rather than because of competition, which is being restricted. So the legislators needs to be very careful about how this is addressed in the bill itself when it comes to making the recommendation in terms of introducing regulations. But recommendations that there has to be a clear, objective, and evidence-based criteria before a maximum price regulation is imposed. And also taking into account of the pricing structure that currently is used for MRGP, which is a maximum refined gas price, refinery gate price, and then the maximum retail price for LPG. To make sure that if the gas, the LPGs come to under the umbrella of the gas, Act or the gas bill, there has to be an alignment, because ordinarily, before imposing any maximum price, one will give competition opportunity to really set the price in the market. Then clause 5 to 9 deals like also with enforcement. I'll just touch briefly on this because the bill really provide NESA with a stronger inspection, investigation, and enforcement powers. So this will result in increased compliance and reporting requirements for industry participants who are particularly licensed. So from our side, the strong enforcement can help to address some non-compliant operators, but compliant businesses should not face disproportionate administrative burdens. We must try to limit the regulatory workload as far as possible. So our recommendation would be to support stronger enforcement, particularly against non-compliant or unlicensed and unsafe operators, provided that enforcement is consistent and applied equally across the formal and informal market. And then I'll just move on to licensing. Here, the key provision here is the trading and the construction and operation of specified gas infrastructure, which require licenses. It's important to recognize that, existing licenses under the Petroleum Products Act provides regulatory continuity and certainty, and this avoids unnecessary administrative and operational disruption, and it protects existing investment and enables LPG businesses to continue operating without interruption during the transition to new legislative framework. So should the LPG be fully brought under the ambit of the Gas Act, it will be very important that the current licensing regime is managed in a way doesn't cause disruption while we are transitioning to the new framework. So the licensing framework itself should facilitate investment while maintaining appropriate regulatory oversight. Licensing process, themselves should be efficient, transparent, and subject to defined timelines in transition, during the transition, to ensure that the industry is not unfairly disrupted. And it's also important that, this is our recommendation, that there should be some sort of exemption in terms who can be licensed. There are certain activities that based on the minimum volume might be exempted. Also, should there be a move to gas, bill, there has to be clear transitional arrangement to protect existing licenses and approvals and provide existing operators with sufficient time to comply with any new licensing, registration, or regulatory requirements. I think it's important, clause 18, we look into that, and then which talks predominantly about certain customers with an exclusive distribution area may be required to purchase from a licensed distributor. So this needs to be navigated very carefully because it could affect competition and also alternative supply arrangements. Our comment here is that the interaction between exclusive areas and eligible customers and alternative LPG or gas suppliers requires clarification. The Gas Act needs to enforce trading with licensed distributors only. Security of supply. I think it's very important that, when we think about security of supply, we factor the role that is also played by LPG. Because LPG itself is currently providing a significant role in ensuring that the energy requirements of the country are met by various customers across the value chain. So it means, therefore, that security of supply planning should recognize LPG or liquefied petroleum gas as a complementary energy source, not focus exclusively on natural gas or an LNG. And then our recommendation is that explicit recognition of LPG role in diversification, industrial fuel switching, and reducing pressure arising from the gas cliff that we have heard about in the earlier presentations as well. I think this is our last slide. I think our key request to the committee is as follows: to clarify the boundary between the gas bill and the existing petroleum sector legislation, in particular, the Petroleum Products Act, when it relates to LPG, and protection of investment through predictable tariffs, fair returns, commercially workable third-party access, and clear transitional arrangements. Thirdly, we request explicit recognition of LPG in the security of supply, strategic planning, and integrated energy projects. And fourthly, ensure enforcement and administrative penalties are proportionate, transparent, and risk-based. And fifthly, prevent unnecessary duplication between NESA DMPR role and the municipal and environmental approval processes. Six, request that we require meaningful industry consultation on the gas master plan, regulation, methodologies, and NESA rules. And lastly, we request that to maintain a competitive and investment-friendly gas market while protecting consumers and national security of supply. Thank you very much.
Thank you for your presentation. Can you please take Kosati?
Afternoon, Chair, afternoon, members. Thanks for giving us a chance just to share our presentation. Let me just upload it quickly. My name is Matthew Parks from COSATU, and obviously we have a vested stake in the bill, and in principle we support the bill. Okay, thanks, Chair. I don't think we'll take the full 20 minutes, Chair. I think for us this is a straightforward bill. But let me just say, Chair, on behalf of COSATU, where we have nearly 1.5 million members, many of whom work in the gas sector, but workers across the country who need this bill to come into effect, we support it. We think, Chair, there are huge discoveries which can really be game changers, known and still potential, of the Northern Cape, of the Southern Cape, etc. And Chair, also to bear in mind that our single greatest crisis as a country is our 43.8% unemployment rate. An economy stuck at 1% growth for the past decade and a half plus. So, Chair, for us, the bill helps to unlock the opportunities that gas represents in the near term to attract investment, to also address energy security issues, also to create significant number of jobs. So we support the bill, Chair, but having supported the bill is fine, but also we need to make sure that we capacitate the state to enforce it. We need to make sure that when it comes into effect that we elevate localization, supporting local industries, value chains, workers, products, etc., that we embrace the transformation agenda, and of course we make sure that there is social dialogue adhered to between industry and communities and labor, etc., and local SMEs and so forth. I think first, as a federation, as a trading federation, unemployment is our single greatest priority. We have to deal with it. We saw yesterday's job stats, very depressing. Unemployment has increased to 43.8%. Youth unemployment is above 60%. And so this is what must guide us. Economic growth has been stuck at 1% for so too long. Of course, Chair, we have made significant progress in overcoming load shedding, making progress overcoming load reduction, but we still have an energy crisis, Chair, in terms of the cost of energy being unaffordable for the economy, especially for the industrial sectors. We've seen thousands of jobs being lost, especially among smelters, and there's continuous engagement between Eskom, for example, on the smelters, but how to reduce the price of electricity. So we think gas coming on board can be part of that equation. We also do have a challenge, Chair, of many plants reaching the end of the lifespan, and even when we try to extend them, there's still real challenges there. And of course, Chair, electricity and energy should be growth industries where we can not just satisfy domestic demand for it, but also once again begin to export surplus electricity to neighboring states who also desperately need. And of course, Chair, we need to unlock new industries to absorb workers. So we think, Chair, that the gas discoveries off of our coast really prevent a useful pipeline, useful opportunity. Chair, I think to state the obvious that energy security is critical for looking at mining, manufacturing, agriculture, and service delivery. We think gas will be a useful part of this in terms of dispatchable power. It can complement other sources of energy, including renewables, and also plays a critical role for industrial development, be it on chemicals, fertilizers, steel, transport, etc. We have had a lot of discussions, Chair, at NEDLAC. Parliament also too has had discussion with the department around the IRP, and of course, gas is a critical part of that. We've always supported the energy mix, and this is one critical anchor to it. We also do think, Chair, that it offers low emissions as we seek to say, how do we try to lower our carbon footprint? How do we try to adjust industry for the CBAM, especially for those who export to Europe and so on. So again, Chair, we've got huge discoveries of the Northern and Southern Cape. We need to exploit these to create jobs. And I think, Chair, it would be a real tragedy if Namibia can correctly jump into this full steam and we are found lagging behind. We think there's useful opportunities around creating jobs, and obviously it's always difficult to be exactly sure how many jobs you would create and so forth. But there are estimates between direct jobs between 20,000 and 30,000, whether it's on exploration or drilling or production, around the terminals, the plants, etc. Indirect jobs in the value chains could be between 60 and 120,000, whether it's manufacturing or steel, engineering, logistics, ports, etc. And of course, jobs as a result of workers having income, spending money, businesses spending money, etc. 40 to 80,000. So, Chair, estimates will range between 120 and 235,000 jobs. Even, Chair, if it's only a quarter of that, that's what we need. We can't afford to be missing out on these opportunities. So obviously, the Western Cape, Northern Cape, Southern Cape would benefit significantly, as well as the Eastern Cape. And for some of these areas, like Namaqualand, this would be a game changer. For parts of the Eastern Cape, this would have a huge benefit. If we look at Mossel Bay, Chair, where Mosgas has been in real trouble for some time, this would be key. Huge amounts of money have been spent on Saldanha Bay. We know how to reap those rewards. So I think, Chair, for us, these will be quite exciting opportunities for workers, for businesses, for the economy, for the state. But we also do fear, Chair, that if we have these delays, it means we'll miss out on these opportunities. And investors will obviously then go to other countries who might be further down the road than us, be it Mozambique or Namibia, etc. And again, Chair, to state the obvious, we must always be guided by our unemployment crisis. And when we have 4 out of 10 South Africans who just can't find work, we just don't think we should be waiting a single day longer. Chair, on the specific parts of the bill, so as COSATU, we supported. We've had positive engagements with government on it, with business on it at NEDLAC. We think it provides a rational set of licensing requirements, capacity inspectors to make sure license holders comply with it, and so forth. But this does require that we make sure the department has got the adequate resources, including inspectors. It provides, obviously, critical obligations to industry around rehabilitation, monitoring compliance, marine and environmental management, etc. And again, Chair, we must make sure that when this comes into law, it's not just a question of nice progressive words on a bill, but that actually industry complies with it. We've seen the real crisis in the mining industry. Despite the progressive laws, many mining companies have just simply ignored it, and there's been a real crisis for host communities as a consequence. Chair, we think it's quite useful that the bill elevates the master plan into the bill, and that's critical, Chair. Some of the master plans are quite far down the road. Good discussion between government, business, and labor, useful targets, useful interventions, job creation objectives, etc., localization. So I think, Chair, elevating the master plan into the bill also helps to send a signal of the seriousness of the state to industry, to labor, about unlocking this industry. And we think, Chair, obviously, as part of the bill recognizes the specific roles of business and labor on such a master plan, because government must obviously lead, but it can't do everything. It needs to have social partners on board to really make sure we achieve the objectives. Chair, the bill correctly makes reference to broad-based Black economic empowerment provisions. We support that in full. We know that many have chosen to denigrate BE. We don't support that. Chair, I think for us it's useful that the bill anchors this with the Triple BE Act under DTIC. And I think we'd be keen to say, how do we elevate worker ownership programs so workers have a stake, have shares in the industry, there's money in their pockets, and similarly with regards to community trust, but to make sure this reaches the people on the ground, not just a well-connected elite. How do we use it to support local SMEs, local industries, specifically around making sure industries or companies comply with the skills targets, especially for Black professionals, artisans, etc. And of course, Chair, this can be a really strategic benefit to the Northern, Western, Southern Cape, and of course the Eastern Cape as well. So, Chair, just getting towards the end, I think from our side, we're happy with this bill as Labour, as COSATU. We think the tabling is long overdue. It left NEDLAC about, I think, 3 years ago, if memory serves me correct. But we think, Chair, when we're so desperate for economic growth, we're so desperate to create jobs, any further delays will actually undermine investor confidence and deny the opportunity to create jobs for South African workers. Our recommendations, Chair, are simple. We will support Parliament passing the bill. We hope it can be expedited. But of course, Chair, again, when we have the medium-term budget policy statement in October, the budget for next year and the MTEF period, we need to make sure that the department, the regulatory authorities have the resources, have the capacity to enforce compliance by industry. Particularly, we need to make sure there's reports when it does come into effect, that the portfolio committee does receive continuous reports around the jobs targets, localization, BE targets, and that these are adhered to by different role players, especially industry. And of course, to make sure that where investments are done, exploration is done, etc., there is a requisite environmental impact management and so on. So, Chair, in conclusion, we think this bill is progressive. It should be supported. We think it can help unlock this industry. As one of the earlier speakers has said, it provides a rational framework to drive the industry. And of course, it must specifically focus on energy security, job creation, transformation, localization, etc. So, Chair, in a nutshell, we support this bill, and as COSATU, we urge Parliament to pass it as one of our critical interventions to secure energy supply, create jobs, nurture industries, unlock value chains, and stimulate economic growth. And these, Chair, would obviously then generate the tax revenue the state requires to fund public services and so forth. So that's our presentation, Chair, and thanks to Chair and thanks to all the members for giving us space to share our views. Thank you, Chair.
Thank you very much for that presentation. Please stay on for the clarity-seeking questions after this presentation that we will get from the WWF. I see you already have the co-hosting rights, Mr. Rila, so the platform is yours. Do share your presentation.
Thank you. I hope you can see my presentation. Chairperson, honorable members of the committee.
Yes, you can see.
Perfect. Thank you. And thank you for the opportunity to address you today on the gas bill. My name is James Rila. I'm a senior technical specialist and I represent WWF South Africa. We work in a long-term relationship between people and nature across land, biodiversity, sustainable food systems, fresh water, marine, and climate. And energy obviously sits at the center of that work because how South Africa generates power shapes almost everything else on that list. We've made a detailed written submission on 7th of August, and I would like to use this time to highlight the points in that submission that matter most to this committee's decision. And also, I'd like to draw your attention to several points raised by another submission from Just Share, which we believe strengthen rather than duplicate our own case. So I think our position is straightforward. We oppose this bill in its current form. not because South Africa should never use gas, but because the legislation is locking in large-scale, high-emissions gas infrastructure for decades, ahead of and without reference to the one planning process that is supposed to tell us whether that infrastructure is needed at all, which is our integrated energy plan. So that plan is currently under development. It is long overdue, and it is mandated by the National Energy Act of 2008, but doesn't yet exist in a final form. So this committee is therefore being asked to approve the legal architecture for a gas economy before the country has decided on the basis of evidence whether it is needed or how large that gas economy should be. And the sequencing problem isn't a technicality. So Clause 27 of the bill establishes the Gas Master Plan as the primary planning instrument for the sector, but a sectoral plan cannot substitute for an economy-wide plan. The Gas Master Plan starts from the assumption that gas is coming. An integrated energy plan starts from the question of what South Africa's economy and grid actually needs, at what cost, on what time frame, and compared to every other option available to us. So coal retirement schedules, storage, transmission build-out, demand-side measures, renewables. Only one of these two processes is capable of telling this committee whether the infrastructure the bill enables is the right size or the right technology at all. WWF is not simply asserting that gas is unnecessary. Through broad consultation with civil society, government, and labor and business, we developed an illustrative people's energy plan. It was technically underpinned by energy economic modeling from the University of Cape Town's Energy Systems Research Group. And I'll come back to what the modeling shows. But the procedural recommendation that follows from it is simple. Government should complete the integrated energy plan first, and legislation, this bill, the revised Gas Act, and the Gas Master Plan, and the Integrated Resource Plan, and all those related instruments should follow from it, not precede it. Now, even on fairly narrow economic grounds, the case for rushing ahead with large-scale offshore exploration is fairly weak. South Africa's offshore gas and oil resources sit in some of the most difficult waters in the world for exploration. We have strong, persistent currents, we have deep water, we have a punishing wave climate, which is great for wave energy, but is really problematic for sort of deep sea drilling. And that makes the upstream development process slow and expensive. Realistic timelines put large-scale production about a decade away, which means that this upstream gas will arrive too late to address our so-called gas cliff, which is the very problem that is being justified by the crisis that we are rushing this through on. And look, we've already seen these challenges play out. Total, Qatar Energy, and CNRL walked away from the 11B, 12B exploration blocks off our coast because they couldn't secure the price guarantees they wanted from PetroSA to develop it. And we've seen in the Namibia's Orange Basin, Shell alone spent close to $400 million on 9 wells before writing the discovery down. Now we know that there is progress happening in terms of exploration in that space, but this is the kind of price tag of doing business in this deep water environment. And the price tag is something that South African government would effectively be asked to underwrite. It's also expensive in a way that shifts the risk onto the state. So government, as an anchor tenant for gas to power, would need to guarantee minimum offtake volumes and prices to attract commercial investment. This removes any benefit to South Africa other than supply. When gas prices are low, we still have to pay the recommended minimum, the agreed minimum, whilst we're just as exposed as ever to price spikes, as we saw when the Strait of Hormuz was blocked. And Rystad Energy, which is one of the sector's own analytics firms, estimates that in any global low-carbon transition, up to 130% of government's potential tax revenue from the sector is at risk. And even a moderate scenario could see 97%, and even slightly below normal, over 90% of the government revenue. What this means is that by pursuing the infrastructural build out. South Africa could end up subsidizing exploration, subsidizing the infrastructure, providing rebates and incentives, and actually receive nothing in return in terms of income for the state. And I think we all can agree that jobs is a critical element, but the employment case isn't as strong as it's presented. So a lot of the upstream offshore work is extremely highly skilled, and South Africa actually possesses a lot of those skills, but they are currently in workers who work offshore, and that would likely to be the case. And when they work in this offshore environment, they're largely taxes exempt. The question is whether those offshore workers would violate that tax exemption in order to work locally, or they would maintain their 181-day minimum offshore to protect that tax exemption. I suspect the latter. And so there's the onshore elements are the only bits that would provide the tax revenue. And modeling in terms of the actual numbers of jobs shows that the high gas pathway, if you look on the graphs on the right, that is the green scenario that was modeled in line with the previous draft gas master plan, produces far fewer energy sector jobs by 2050, and in fact over much of the period, than a pathway that's aligned with net zero. So you can see these are differentiated by primary educated, middle educated, secondary, and this tertiary high skilled sort of technical jobs. The point that was raised as well about gas being a transition fuel, it's shaped this debate a lot internationally, but it's not. And the evidence-based position here is that expanding fossil fuel infrastructure is not a requirement for our transition to a low carbon economy within South Africa or globally. There is more than adequate supply to cover the needs of the transition in the global, from currently exploited fields. Or methane leakage across the gas supply chain is very well documented in peer-reviewed literature. And at the leakage rates frequently observed in the field, gas's lifetime climate impact converges with that of coal. So it's not a very low sort of carbon option. In fact, by comparison, the full life cycle emissions of renewable energy sources sit at around 7% of those of liquefied natural gas. South Africa, frankly, cannot meet its net zero commitment by 2050 while expanding fossil fuel consumption, although we know that we actually can meet that commitment with significant GDP growth. And what's also important is that our largest export markets, the European Union, China, the United Kingdom, the United States, Japan, South Korea, have all adopted net zero targets of their own, and carbon border measures from the EU are already starting to bite on trade. So failure to pursue the net zero transition in a reasonable manner put us at risk of not being able to export to those markets. So what does the evidence actually show that gas should look like in our system? The illustrative People's Energy Plan that we did together with input from stakeholders and government, labor, business, civil society, and modeled by this independent university research group, gives us some sense of that, as does the NBI gas pathways. And this IPEP modeling finds that achieving net zero by 2050, whilst still expanding free basic electricity, expanding transport and freight access, and reducing pollution is not only feasible, but in many respects it's preferable to business as usual. And while most scenarios modeled do include some gas, what they do not support is a gas economy sized to the current gas master's plan. Gas's role in a well-planned electrical system is small, used at a low availability factor, as backup and as peaking capacity that helps firm up a system that's dominated by wind and solar, not as a parallel pillar of the energy mix in its own right. And other gas usage in direct industries can be transformed in many cases, with a short-term window of need to cover that transition. So scaling gas investment to the draft gas master plan's ambitions rather than to the peaking role measurably weakens GDP and overall employment relative to the pathway and the model that the modeling recommends. So this is the evidence base the committee should be asking government to test its assumptions against. It's exactly the evidence base that integrated energy plan is supposed to produce on a whole economy basis and before legislation like this is finalized. I want to turn now to points that were raised by Just Share because they reinforce our concern from a different angle, which is the bill's legal architecture. And key amongst these is that the bill as drafted does not integrate climate governance at all. It doesn't reference the Climate Change Act. It doesn't require decision makers to consider greenhouse gas emissions, carbon budgets, or South Africa's nationally determined contribution when licensing the new gas infrastructure. But in contrast, Section 7 of the Climate Change Act requires every organ of state exercising a power affected by climate change to align its decisions with our national climate response. And this bill does not give effect to that duty. And this matters practically, not just legally. Pipelines, LNG terminals, gas-fired power stations are built to run for decades, and licensing them without requiring an assessment of stranded asset risk or of lower carbon alternatives is how a country locks in emissions and locks in costs at the same time. But it also matters constitutionally. Just Share points to the International Court of Justice's 2025 or July 25 advisory opinion, which confirmed that states have due diligence obligations to regulate emissions producing activities and must apply the highest possible ambition in decisions like this one, including energy infrastructure planning. And combined with our own constitutional court's recognition in the Deadly Air judgment that the environmental right in Section 24 is immediately enforceable, this bill's silence on climate is not a drafting oversight that the committee can treat as minor. It's a legal exposure. There are also two process concerns that we would like to endorse that were raised by Just Share. The first is public participation. Clause 14 of the bill only allows objections to gas licenses from parties whose rights are materially and adversely affected. This is a far narrower test than the interested and affected party standard used throughout South Africa's environmental legislation. This is quite a deviation. And that threshold risks excluding exactly the organizations and communities with the scientific, the local and technical knowledge that improves those decisions. And I would say it sits very uneasily against a bill that also allows broad ministerial exemptions under Clause 39 with very little published justification or public input. And secondly, indirectly relevant to how this committee weighs the arguments before it, Just Share documents in a separate report called the Obstruction Playbook, a consistent pattern over the last 2 decades of high-emitting industries using narratives, energy security, job creation, and our status as a developing economy, and gas as a transition fuel, the first 3 of which are all utterly legitimate, but perhaps used as a smokescreen to slow down and weaken South Africa's climate regulation. And this gas cliff argument is exactly one of those narratives they've tracked. And we're not suggesting bad faith on the part of any specific proponent, but we are suggesting that the claims about anchor demand, urgency, and national interest deserve the same rigorous evidence-based scrutiny this committee would apply to any other multi-decade, multi-billion rand infrastructure commitment. And that scrutiny is best applied by a completed integrated energy plan, not by this bill's own explanatory memorandum. Just Share has asked, and we support this request, that every submission made on this bill, including both of ours, be published in full for transparency purposes. So, 3 recommendations. First, this committee should ideally request that the Department of Electricity and Energy complete their integrated energy plan through broad public consultation and transparent development of scenarios and exposure of assumptions before this bill proceeds further, and that the bill then be revised in light of what that plan finds. And secondly, if the bill does proceed regardless, it must be amended to embed South Africa's existing climate law, express consistency with the Climate Change Act, the National Environmental Management Act, and our nationally determined contribution, and it must include mandatory assessment of stranded asset risks and lower carbon alternatives before new gas facilities or strategic projects are approved. And it must also require a proper strategic environmental and climate assessment attached to the gas master plan when it is finalized. And thirdly, the bill's participation and transparency provisions need to be brought up to the standard the rest of our environmental law already sets: an inclusive, interested and affected party test for objections, published reasons for ministerial objections, determinations and exemptions, and public access to all submissions made on this bill, including our own. Thank you.
Thank you, WWF. Are there any clarification questions?
If you are in possession of a power
Okay, so this was the last presentation for the day. And I do wish to indicate, or rather remind everyone that on the 18th next week, we will be receiving the response from the department on all the submissions, votes that were made here on this platform from yesterday and today, but also the written submissions that may have not been presented here. So both of these presentations, which are the same, even for those that presented here, will be responded to. So we do wish to thank everyone. We thank all the stakeholders that have made their submissions. And we wish to thank our parliamentary legal service that has been part of this process, and also our support staff for all their contributions, and as well as the people of South Africa that have been following. Let's meet again next week on the 18th when we begin with our deliberations following the response from the departments. Thank you so much, everyone, for your participation. Thank you. Have a great day, Heather.
Thanks, Chair.
Thank you, Chair.
Thank you, Chair. Bye, colleagues.
Thank you. Goodbye.
Thank you, Chair.
Thank you, Chair.
Thank you, Chair.